Good morning, everyone. We'll be starting in a few minutes. Just waiting for the court reporter to return. Madam Court Reporter? Doesn't sound like she's back yet. Know any good discovery jokes? I'm sure there's some out there. There's plenty of lawyer jokes.
Oh, hi, Mr. Kern. It's Linda Crockett.
Oh, good. Okay.
Do you know when you'd like the transcript?
Just standard.
Oh, regular? Okay.
Yeah, that'll be fine.
All right. Thank you.
Thank you.
Okay. Madam Court Reporter, are you ready to proceed?
I certainly am, Commissioner.
Great. All right. Well, why don't we go ahead and get started? Madam Secretary, we are streaming this on YouTube, so if you could let me know when we're ready.
We are ready, sir.
Great, thank you. All right, we'll go on the record. Good morning, everyone. We are here today for case 9667, which was initiating an investigation into a petition filed by the Maryland Office of People's Counsel to investigate the future of First Energy's relationship with Potomac Edison in light of recent events. As you know, the Office of People's Counsel on October 15th filed a motion to compel. On the 22nd, the Commission issued an order delegating consideration of that motion and any related filings to myself. The only related filing that we received was on November 1st from Potomac Edison, which was a reply to OPC's motion to compel. I see there are several parties that have joined us this morning. I don't believe anyone else has made any other filings. If there have been some, you'll have to let me know. But before we get started with that, why don't we start with entry of appearances, starting with the Office of People's Counsel.
Good morning, Your Honor. Joseph Cleaver on behalf of the Office of People's Counsel. I'm joined today by Nikki Wiggins, also on behalf of OPC.
Morning. Potomac Edison.
Good morning, Your Honor. Max Curran on behalf of Potomac Edison. I'm joined this morning by Jeffrey Trout, who is counsel for Potomac Edison as well. I'd like to also enter the appearance of my colleagues at Venable, Mr. Christopher Gunderson and Ms. Susan Chipper. Proceedings.
Morning.
Morning.
I see we have someone from the Public Service Commission staff.
Good morning, Your Honor. Peter Wilson, appearing on behalf of technical staff.
Good morning. And Ms. Miller. Good morning.
Good morning, Commissioner Linton. Good to see you. Susan Miller, appearing on behalf of Solar United Neighbors of Maryland, and we did not make any filing pertaining to the motion to compel.
Okay. Thank you. All right. So let me find out first from the staff. You did not make any filing that was in the record?
No, we didn't, Your Honor.
Okay.
We're just here as a party, and I expect I'll have little or nothing to say today.
Okay. Thank you. All right, let's begin first. And are there any preliminary issues that we need to discuss before we get started?
None, Your Honor.
Okay.
I don't believe so, Your Honor.
Okay. Has there been any resolution of the dispute? Is it still pending? Or as a dispute, as People's Counsel initiated back on the 15th, does it remain as it was initiated back then?
Your Honor, thank you. All of the items in controversy identified in OPC's October 15th motion to compel are still at issue today. As we outlined in the motion, we did work cooperatively with counsel in terms of trying to resolve the issues in good faith. We did resolve several of the questions where we had initially concluded that the information provided was incomplete. But unfortunately, these very few limited data requests that are the subject of the motion to compel remain.
All right, thank you. Then why don't we go ahead and get started? And we have 6 items that the People's Counsel has raised for consideration in this proceeding. So we'll just take them one at a time. I don't think it's necessary for the parties to restate their arguments that have already been filed in the comments. I would like to hear from the Office of People's Counsel very briefly, since Potomac Edison filed a response on 11/1. You just stated earlier that the 6 items are still in dispute. Have they been resolved as a result of what you've received from Potomac Edison on November 1st?
Unfortunately not, Your Honor. The filing that the company made on November 1st doesn't provide the additional information necessary to perform an analysis under the terms of the Commission's order. So no, unfortunately, Your Honor. I wish I could tell you otherwise, but that did not. That filing did not contain the information we seek.
All right, then why don't we go ahead and begin then. We'll start with OPC's request 1-1, which has a couple of, well, has 4 subsets to it. I have a couple of questions for the Office of People's Counsel just to make sure I understand what you're seeking here. Because I know that the company has responded at least 3 times to this request. Can you help me to understand what else you're looking for, and what else would you believe is not being provided to you this time?
Sure, and Your Honor, I can jump right in on 1-1. If I may have your indulgence just to provide a couple of comments, a couple of introductory comments before I jump in to the specific question. I think that may be helpful to, providing a context for the remaining issues and why OPC continues to seek the information it seeks.
Sure.
Okay, thank you, Your Honor. I appreciate that. I'll be brief. Your Honor, the situation giving rise to this docket has been in the media and in the trade press now for over a year. We first started hearing about this issue in late 2020. I think it's important, that we all have a tendency over time when we hear about things over an extended period, we kind of become numb to them and they kind of lose their urgency. But this is a serious and severe set of facts with respect to Potomac Edison's customers that is of significant concern to OPC based on its statutory duties. 10 years ago, this commission in case 9233 entrusted Potomac Edison to First Energy. And we now know, based on what has come out and what has been developed over the past year, that trust was violated repeatedly and extensively. The U.S. attorney who prosecuted Generation Now and who was at the head of the criminal case, the federal criminal case arising out of this situation, described this as likely the largest bribery money laundering scheme ever perpetrated against the people of the state of Ohio. And we now know for a fact that PE used funds that had been collected from Maryland ratepayers to further those purposes. And if you think about that for a moment, just imagine the shock that would have befallen the commissioners that sat there in case number 9233 10 years ago, had they known about that as they were being asked to entrust Potomac Edison to First Energy. Beyond those concerns, and separately, Potomac Edison on March 31st filed with this commission a director appointment and nomination agreement where two designees of Carl Icon's group, called the Icon Group, which I'll refer to as we go forward as the Icon Agreement, would be given 2 seats on the board. The board would expand from 12 to 14 seats, and those 2 individuals would be given considerable rights under the agreement that exceed those of other board members. And beyond that, there's language in the agreement that mirrors this Maryland's statute that triggers the need for commission approval of a transaction. And it says that this transaction does not do that. And it almost mirrors the language verbatim. The commission has never had before it an agreement like that, where some outside entity would obtain 2 board seats. And the agreement itself attempts to go around the statute by including language that says, effectively says the statute doesn't apply. Again, fast forward or go back 10 years, think about those commissioners that were again asked to entrust Potomac Edison to First Energy, and think if they had known then about this agreement in light of Mr. Icon's well-known reputation, in light of the circumstances that gave rise to the agreement, and in light of the language and the rights that his designees are given. Again, I think that would have been shocking to those commissioners. Under the PUA, OPC is required, the language is shall, petition the commission to open an investigation when OPC considers it necessary to protect the interests of customers. And based on those facts that I've just described, OPC reached that conclusion, and so therefore was required under statute to file the petition that it did. And fortunately, the PSC agreed with us that an investigation was necessary. Of course, as Your Honor well knows, the PSC limited the scope of what this proceeding would entail, but the PSC did determine that a proceeding was necessary. And as Your Honor also knows, the commission carved out 3 separate areas of inquiry appropriate for discovery. The first one regarding funds from the money pool is not relevant to the matters before Your Honor this morning, so I won't talk about that one. But the second one is whether and to what extent First Energy is using, or intends to use any funds from PE to pay for the bribes, lobbying costs, legal fees, or any other costs associated with the misconduct by First Energy. The commission set that issue for discovery even after it had had the opportunity to review what Potomac Edison said about the $38,000 and the investigation, and heard Potomac Edison's argument that based on that investigation and that determination that only $38,000 of Potomac Edison Maryland ratepayer money was used for these activities, that the commission should deny the petition. The commission heard that and still nonetheless determined that this was an appropriate area of inquiry. The second issue of inquiry that the commission deemed appropriate that's relevant to the matters before Your Honor this morning is item C, the extent to which the Icon agreement may potentially cause the Icon appointed directors to exercise substantial influence over PE as set forth in section 6105 of the Public Utilities article. And again, the commission determined that this was an appropriate area of inquiry even after having had the opportunity to review the Icon agreement, which Potomac Edison filed with the commission on March 31st. So the commission had the entire agreement itself before it, and yet still determined that this was appropriate to try to ascertain whether this agreement would give the Icon designees the power and the ability to exercise substantial influence over Potomac Edison. Your Honor, we saw a filing earlier this week that Potomac Edison made, which said that Standard & Poor's had improved its credit rating from BB to BB plus. And I can tell you, as counsel for the residential ratepayers of Maryland, I was very pleased to see that. That's certainly a positive development, and I'm sure you'll hear about it from my co-counsel or our opposing counsel, I should say, today, as they respond to the arguments that we make. But I would note a few things, Your Honor. One, the credit rating is still below what it was before the scandal. Two, the company is still on credit watch. And three, that's not the end of the story. What we're really trying to get at with respect to the discovery that we seek that falls under that first area of inquiry that I discussed, the payment of Maryland ratepayers of money used for any of these purposes associated with the scandal. We want to determine what PE paid, and we want to make sure that it's correct. That's our duty. It's our statutory duty. So we're pleased to hear that Potomac Edison's credit rating has improved, but it doesn't speak to that issue. And of course, it doesn't speak to the issue of the extent to which the ICON designees will obtain the ability to exercise substantial influence over Potomac Edison as a result of the ICON agreement. Thank you for that, Your Honor. If I could now go into 1-1, if that's permissible.
Your Honor,
Well,
and
actually-
we heard briefly before.
Yeah,
Just
certainly.
response.
Please proceed.
Thank you. Thank you, Commissioner Linton, and thank you for making yourself available today to hear this issue. Counsel for OPC just went through a litany of the issues that it had sponsored to the commission earlier this year. And quite frankly, this motions hearing is not about that. It's about whether or not Potomac Edison has lived up to its discovery obligations, in which it has. And we are happy to go through each one of these 6 remaining issues. As the commission can see, we've been provided very fulsome responses from Potomac Edison and have worked collaboratively with OPC over the last several months to bring just these few remaining issues to you. But this is, again, not about rehashing what was in Potomac OPC's initial investigative petition to you. It's about whether or not your public service company that you regulate has lived up to the obligations that you have asked us to live up to, in which we have. And at this point, we have not only provided the Office of People's Counsel with all information that is within our possession and control regarding the limited issues that Your Honor and your colleagues have restricted this proceeding to, but we've gone above and beyond that when we could. As you could tell from each of our responses, where we've given fulsome responses and even gone back and supplemented them where we thought it would be helpful and constructive to our friends at OPC. However, what this matter has restricted or limited itself to now is OPC wants to go beyond what is within the possession and control of Potomac Edison, and is seeking all manners of information regarding an investigation of Ohio employees of First Energy, which is certainly outside the bounds of your order, and certainly outside the scope and authorities of Potomac Edison to be able to acquire and provide. They're also seeking settlement communications between third parties who are not regulated by the Maryland Public Service Commission. And that, again, would be improper for this commission to order the disclosure of that information. And in a third category in which they seek in these limited DRs that we're disputing is the board materials of First Energy, the parent corporation of PE, which the commission does not have regulatory authority over in this context, and which they're seeking information on all other matters unrelated to Potomac Edison. So while we've been cooperative, while we have provided an abundance of information, which OPC must acknowledge today, what the company is not prepared to do is to provide materials that are outside of the scope of this commission's order and outside of the possession and control of Potomac Edison. I will tell you, because we wanted to avoid coming before you, Your Honor, we've not only provided what information was within our control, but we've provided all cost information that has been allocated from First Energy to Potomac Edison. We provided the last 10 years of payments of Potomac Edison to its outside vendors. They have 10 years of information on all of those costs. They have all the cost allocations from First Energy down to Potomac Edison. That was over and above the specific request in this case, which was which funds of Potomac Edison's were used for these misallocated vendor services. So that's why we're a bit exasperated to come before you today, because as Mr. Cleaver indicated in his opening statement, he wants to go back to salacious news stories in Ohio, but that's not what this case is about. This case is about, and this motion before you today is, Potomac Edison, have you lived up to your obligations to provide the information on the issues that the commission restricted this proceeding to? And the answer is absolutely. We've gone above and beyond, and we have fulfilled our obligations to this commission. And we're happy to go through each one of these remaining DRs and show that we've answered them fully. And to the extent that we have not, they're seeking information that is either privileged information of First Energy, which would be improper for this commission to demand or compel, or it's regarding settlement communications. And this commission has never, in my experience, ever required settlement communications between third parties that you don't regulate to compel their production. It simply is improper under your own precedent, but also under federal rules. So that's really what is at the heart before you today. And I appreciate the opportunity to respond to Mr. Cleaver, but I thought it was important, Your Honor, before we began, to give you that context.
Thank you, Mr. Curran. And thank you, Mr. Cleaver, for your opening statements. Why don't we go ahead and get started then by looking at OPC 1-1. And Mr. Cleaver, just to repeat my question from earlier, I noted that the company has provided 3 different responses to 1-1. So help me to understand what has not been answered, and at least not answered to the People's Council's satisfaction.
Sure. And thank you for the opportunity, Your Honor. OPC DR 1-1 asks a series of questions about the investigation that determined, and this is according to PE, that the Potomac Edison Maryland customers had been overcharged $38,000. And the question asks, among other things, it asks Potomac Edison to describe the analysis that it undertook and to provide all documentation that supports the statement about the $38,000 limit, including all reports, analysis, studies, or assessments conducted by or for PE of the charges that were improperly classified. And what we've gotten with respect to this analysis is an explanation that the analysis involved looking at funds that were initially incurred by First Energy Service Company and allocated to PE in accordance with the cost allocation manual in the 2018 rate case. That's the Maryland rate case 9490. We've gotten the identification of 3 First Energy employees that were involved in the analysis, not Potomac Edison, but First Energy. And we've received a spreadsheet that contain a bunch of numbers that show a bunch of entries that show payments to various entities that, based on their names, appear to be associated with the bribery scandal. And if you look, there's some to reach the point of $38,000. Those pieces of information are admittedly and undoubtedly responsive to the question. but the answer is not complete, and that's the problem. The information that we have doesn't tell us how the company arrived at the $38,000 figure. We only have that information about they were allocated costs from the service company. We know the 3 First Energy employees, and we've seen a spreadsheet of the entries. But we don't understand how the analysis was performed. We don't understand why this happened. We don't understand what the analysis uncovered in terms of how this could have occurred, why FESC had allocated these costs to PE, and why PE didn't object to those costs. That's important to making sure and that the claim that only $38,000 is accurate. Of course, Your Honor, regulation, as Your Honor well knows, entails a fair amount of trust. But in light of the highly unusual facts that gave rise to this case, I'm sure you can forgive us for simply wanting to verify ourselves that all costs that PE ratepayers made that were used for the purposes of the Ohio activities are known and properly accounted for. We're talking about a total, Your Honor, of about, just off the top of my head, about $64 million, I think, because you've got I think there's a $60 million figure associated with the Generation Now scandal, and then a $4 million figure associated with the alleged payment to a regulatory official. So you're talking about roughly close to $65 million. And this analysis says, well, Maryland customers only paid $38,000. That's like less than a 1/1000th of 1% of the funding. So it's important to understand how this analysis was conducted, what it entailed for First Energy to reach this conclusion that only $38,000 had been paid to Maryland customers. It may be accurate. I certainly am not suggesting that OPC's position is that it's wrong. It may be accurate. But it's important for OPC to be able to investigate that and confirm that. That's the purpose of discovery, is to, as Your Honor well knows, is to understand the facts surrounding a litigated dispute, so that when we come before the commission, we all are fully informed and we're not, coming in a state of confusion and asking all kinds of questions on the stand. This is an effort to understand the analysis, to understand how the company conducted the review and the assessment of the charges and arrived at this $38,000 figure. So we have, Your Honor, you're correct. We have been given some information that is responsive, but it's incomplete.
Thank you. So it sounds as though you're focused mostly on 1-1C. If I were to pull one of the data requests out among the 4 for 1-1, is that fair to say?
I think that's correct from memory, Your Honor. Could you give me your indulgence just for a moment while we pull up that specific request?
Sure.
Better responses. Yep, simple. The one that says. Okay, we have a. I'm sorry, Your Honor. Bear with me one further second. I apologize.
Certainly. And just, Mr. Curran, as a heads up, I'll be coming to you next to not only have your response, but just to understand if the company has provided methodology for how the assessment was conducted. It sounds as though that's what People's Counsel is looking for, and perhaps whatever ancillary information that comes along with that.
Well, Your Honor, C is an issue. I mean, these are all related questions. I would say that, our view is, one, the description of the analysis is lacking. So that would actually be A. We say describe the analysis. Subpart B, we do have these Excel spreadsheet. We have an Excel spreadsheet, but no further documentation. So the extent that it would shed light on how the analysis was performed, B seeks documents. supporting the statement that it's $38,000. And then, of course, C asks for an explanation of why it was, to use their language, improperly classified or inadequately documented. So, Your Honor, I hate to say that it's all of those, but it really, I think that they're all the responses to each of those three subparts are incomplete. And there could be they do overlap. I mean, there could be certain information that would satisfy or be responsive to both, but I don't want to limit us and paint the wrong picture. I think that what we're seeking falls within all three of those subparts.
Thank you. Mr. Curran.
Your Honor, I'm looking at these responses right here. Each one of them were answered specifically. They wanted us to describe the analysis that we conducted. We described in A the analysis that was conducted of evaluating O&M and capital costs that were allocated to Potomac Edison and that were included in Potomac Edison's distribution rates. And we went beyond that and described the individuals who were involved in performing that analysis. Mr. Valdez, Mr. Richard, Ms. Wright, gave their title and provided the spreadsheet in Part B that provided the time period for the analysis. When you go to the actual spreadsheet, and I got to watch out because this is a confidential response, but it provides each of the vendors that were involved here. It provides how much was assigned to O&M, how much was assigned to capital, gives the total number, which is consistent with what we've provided the commission. There's a spreadsheet analysis for each of the vendor services, how those were assigned for the months from 2014 all the way through 2018, some instances, and further. So it goes through each one of those vendors, describes how they were assigned either capital or O&M. It is a fulsome response. As for D, provide all documentation to support it, we provided that confidential attachment that went through each one of those. As for an explanation as to why the charges, we explained very clearly that these dollars were allocated from First Energy Services Corp. down through the cost allocation manual to Potomac Edison. It is a fulsome response. It is not the response that Mr. Cleaver wants. He wants salacious information about what happened in Ohio, but these are fulsome responses to the questions that were asked. Mr. Cleaver today is asking more questions about this stuff, but those are separate. Those are new questions. He could propound discovery of us for those, but we clearly answered each one of the components of their discovery request, and gave even more of an explanation that the $38,000 was a rounded number and may have to be adjusted depending on the outcome of a depreciation rates. So in each instance, Your Honor, and this is why we're a bit befuddled here today, is that we have really gone out of our way to be very responsive and to live up to our obligations to this commission. So, if he has new questions, that should have been propounded in a subsequent discovery request. But as for 1-1, we have fully answered and complied with the commission's mandate.
Your Honor, may I respond to that?
Yes, Mr. Cleaver.
Your Honor, these aren't new questions. Subpart A asks for a description of the analysis. And the part that the answer to A that Mr. Curran just summarized for you, that the analysis involved evaluating O&M and capital costs that were allocated to PE and included in the case. Your Honor, there are as you know, there's a vast universe of O&M and capital costs that service companies allocate to distribution utilities. That's not remarkable. And so of course, that's where the analysis would begin. That's what you would look at That's the first thing you would do, and I think that's obvious. But describe your analysis. What exactly did you do to determine which of these costs were associated with the bribery scandal? We don't have that information. It's not a new question. We're seeking a description of the analysis. This analysis doesn't provide any insight as to what that evaluation, to use the word in the response, entails. Okay, 3 people from First Energy evaluated all the allocated costs. But what was the methodology? What was the process? How did those 3 individuals determine to only put $38,000 of entries on this spreadsheet? What did the process entail? That is essential information if the parties in this case are going to confirm that that's correct. This is a trust us response, and that response is just not adequate based on the facts of this case and based on the commission's order and the matters that it set aside for discovery. The response to C, again, that's a helpful starting point. The charges were initially incurred and allocated to PE. Well, of course, that's how PE ratepayers would have been charged any cost, whether it's a penny or $1 million, for First Energy's costs associated with its legislative and political and lobbying activities in Ohio. Of course, that's how it would happen. But that doesn't answer the question of why it happened. That's what the question expressly requires. That's why it happened. So these aren't new questions, Your Honor. We just want to obtain an understanding of this analysis, and we have some information about it, bottom line, and we don't. The questions are reasonably calculated to lead to the discovery of admissible evidence, and the questions fall within the scope of what the commission set aside.
Thank you, Mr. Cleaver. And so I've taken a look at some of the responses. It does appear as though there may be some additional materials that Potomac Edison relied on to review and to come to the conclusion that the $38,000 was and I'm using the number that we're talking about today, that number was the number determined as part of the investigation. So are there additional materials, Mr. Curran, that the companies relied on, or additional methodologies or processes that have not been provided to the People's Council?
Not that I'm aware of, Your Honor. All that we've been made aware of the vendors that were at issue. Those vendors were allocated, as we indicated in our response, from First Energy Services Corp. That's the information that's provided. All those vendors are identified in the spreadsheet. There aren't any other vendors. It's those vendors that were involved and allocated to us. We didn't come up with the $38,000. No one came up with the $38,000 number. What happened is we figured out how much of those vendor services were allocated to Potomac Edison. That's the investigation that Potomac Edison engaged in. Figured out who were the vendors that were allocated from the First Energy Services Corp to them. Determine how much were assigned to capital, how much were assigned to O&M in rates, right? That's what that were assigned to them in rates. That's the analysis that they did. There isn't anything else that's everything. The question asked what funds of Potomac Edison were being used. We determined what funds of Potomac Edison were being used by determining what had been allocated to us and what had been allocated to us in rates. What I can tell you, the additional information that was provided, you're asking, believes that there's something else. Since filing this answer, we've provided the Office of People's Counsel and the parties all costs that were allocated from First Energy Potomac Edison. They have, from 2017 to 2020, they have every cost allocated from First Energy Potomac Edison. They have, as a result of a discovery request from MD Sun, they now have every expenditure that Potomac Edison has made over the last 10 years for their outside vendors. So under those recognized FERC accounts, they have all of that information. There is nothing else that Potomac Edison has or did in order to determine its the $38,000 number.
All right, thank you, Mr. Curran. I think that there's the People's Council has made a pretty convincing argument that there could be additional information. Although we're hearing from the company today that there isn't anything additional that's more responsive than what they've already provided. So I am actually going to grant the request from People's Council, but it's limited only to the extent that the company intends to rely on the information as part of the their response in this case. So if there's something additional that you haven't provided and you intend to rely on it at some point in the future, you need to make sure to provide it to the People's Council. It's part of this proceeding. But if you've already provided it and it's already provided, then the People's Council already has it.
Your Honor, can I ask I'm sorry, I apologize. May I ask a question?
Yes.
Just a clarifying question on Your Honor's recent comment. I'm just trying to understand it in light of where we are with this proceeding, because in this case, unlike most docketed cases before the commission where parties are doing discovery, there's not necessarily any hearing set. There's the only next step, so to speak, are I believe a status conference at the end of 4 months of discovery, which will fall sometime right around the end of this month, near the Thanksgiving holiday. So when we appear for a status conference, I'm sure the commission is going to want to know if OPC says, hey, commission, our recommendation is that based on the discovery we conducted and the answers that we received, our recommendation is the commission should do A, B, and C. The commission is going to want to understand the basis for that, I would imagine. So with respect to the caveat or the qualifying statement that Your Honor made about only if Potomac Edison intends to use it, well, if we go for a status conference and we don't have this information, and Potomac Edison says, well, we don't intend to use it. We don't know it, and we can't present a full explanation to the commission of what the next steps should be. So I appreciate Your Honor's response, but I guess I'm just curious as to how that kind of qualification fits within the structure of this case.
That's fair. So at this point, it doesn't appear as though the company has additional information that they can provide in response beyond what they've already provided to you. So, I can direct them to provide more information, but it doesn't appear as though there is anything more. At least that's what they've said. And I don't have anything in front of me.
Your Honor. There isn't anything more to produce. This is what we are going to rely on with respect to this issue. In this case, this is what we're going to rely on. This same analysis. These are the vendors. These are the amounts. These are how they were impacted in rates. We're going to have to go through all of that in the rate case that we file in early 2023. And this is it. We've given them everything. Plus, we've also given them every allocation from FE to PE. Plus, we've given them as I don't know what is beyond belt and suspenders, but whatever a third thing would be, we've given them every payment that PE has made for 10 years to any third-party vendor. So we've exhausted the universe, and it's hard. The position Your Honor is put in, and it's a difficult one, is how do you order the production of something that doesn't exist?
Thank you, Mr. Trout. So just to finish my response, Mr. Cleaver, at that status conference, whenever it's eventually scheduled, at the conclusion of the discovery period, you'll have the opportunity to, as you already stated, present your recommendation for what should occur from here under the conditions and the structure of the proceeding as set up by the commission. The information that you've already collected from the company, and especially the information that you've collected in response to item number 1, I think it gives you a lot of good information. The discovery period certainly isn't over. So if it turns out that some of the additional questions you've raised this morning, to the extent you'd like to pursue additional discovery with those questions, still in the discovery period, and so you certainly could do so. But for the items that are here, again, the company is stating that there's nothing else left to give. So the best I can do is make clear that what they provided to the People's Council is what they have to use in the event of a future proceeding. And if it turns out that they are attempting to use other information, that could be problematic.
Okay, thank you, Your Honor.
Thank you, Mr. Cleaver. So let us proceed then to item number 1-2, which is also related to an internal investigation conducted by the company. Mr. Cleaver.
Yes, thank you, Your Honor. Yeah, and this internal investigation ties into the investigation that we were just talking about in the context of 1-1. In its opposition to OPC's petition, so the petition we filed to asking the commission to open a proceeding, Potomac Edison says that it conducted an independent internal investigation in light of the government investigations currently underway in Ohio. In connection with that internal investigation, First Energy identified certain transactions, including vendor services, that were either improperly classified, misallocated, or lacked proper supporting documentation. That's on page 9 of their June 2021 opposition to the petition. So it was Potomac Edison who put this internal investigation at issue in this case. And after the PSC disagreed that this was a basis to deny the petition and set this matter for discovery, we asked for a copy of this investigation. If it's going to allay our concerns, we want to see it, and it falls directly within the scope of the issues that have been presented. The relevance to the proceeding is evident.
Let me just stop you there, Mr. Cleaver. That sounds like a fairly straightforward request, Mr. Curran.
May I be heard, Your Honor? First of all, the commission, OPC, has received all information of Potomac Edison's. What they're asking for here is the internal investigation of First Energy. The commission limited discovery in this matter to matters that were of Potomac Edison. The commission was very clear about that. What Mr. Cleaver is asking is for a copy of an internal investigation of activity of First Energy employees in Ohio that was conducted and run by First Energy's outside counsel. It is a privileged report. It was conducted by a group of First Energy members of the board of directors. It is not a document that is within the possession and control of Potomac Edison. And the commission was very clear that you were not propounding discovery on third parties. You were permitting discovery to be conducted on Potomac Edison. Even if you could establish some control over First Energy in this matter, in which the commission did not. The commission elected not to do that because that would have been improper. But if you were, as Mr. Cleaver wants to, exert control and discovery over First Energy, what they're seeking is a privileged document that was produced by the outside counsel of First Energy. Potomac Edison cannot waive the privilege of First Energy, its parent. We cannot waive that. Mr. Cleaver is suggesting to you that we are putting that at issue in this case, the internal investigation. We are not, and we did not. We advised the commission of public information that was provided to the SEC. We are not asking the commission in this, nor did we ask the commission at any time for you just to believe an internal investigation that was run by our First Energy's outside counsel. We're not asking you in this case to put your imprimatur on that. You're conducting your own investigation, and Potomac Edison has provided you all the information that's within its possession. What would be improper is for this commission to reach into Ohio to try to regulate through discovery First Energy, the corporate parent, and to seek its privileged information. That's simply improper and should not be done here. Regardless, they have every piece of information they need to do their analysis. They have the vendors. They have all the cost information that's been assigned from First Energy to Potomac Edison. But they want more. They want more, and they want you to compel more. They want you to compel the First Energy Board of Directors board minutes and their privileged investigation that was run by their outside counsel. And that is where we draw the line here. They haven't established relevance because it's not relevant in this investigation. The commission narrowed the scope of issues here to funds of Potomac Edison. And we have provided every bit of information about funds of Potomac Edison. What they want is salacious information that was the result of an investigation about Ohio employees. None of the employees of Potomac Edison were in any way involved in that. Potomac Edison wasn't in any way involved in the Ohio activities. What the commission's interested in is funds of Potomac Edison that were used for any improper purpose. And we have provided OPC, the staff, all the parties in this case, every piece of information regarding our funds. You can't, though, compel First Energy, who you don't regulate, quite frankly, and you don't have jurisdiction over in this matter, and you can't compel them to turn over material produced by their outside counsel. And that's where we draw the line.
So the People's Counsel has asked for a document or the results of an investigation that the company has claimed was conducted by the parent company, First Energy. So help me to understand what we're talking about here. Is this an actual, describe this investigation for me. What's the result of it? We're talking about is it a magazine, is it a book, is it a PowerPoint, is it just is it oral discussion? Help me to understand what it is.
We represent Potomac Edison. We don't represent First Energy here today. I don't know the full scope of First Energy's materials, but what my understanding is, this was materials that were developed by the work product of its outside counsel. And it was under the direction of that outside counsel and a small subset of the First Energy Board of Directors. Those are their documents. So the Board of Directors documents. They are not Potomac Edison's documents. So I can't tell you the full scope of what they are, other than they belong to First Energy. They don't belong to Potomac Edison.
So as Potomac Edison take part in the production of these documents? Certainly some of the data or information that was used in order to come to the conclusions in it included information about Potomac Edison.
Zero. In fact, at the request of OPC, in an effort to try to resolve this dispute before coming to you, we confirmed that In those materials, there is no mention of Potomac Edison or Maryland whatsoever.
So you've
All
had the
this is
opportunity
about
to
is Ohio
review those.
employees.
I'm sorry.
This is about, my understanding, Your Honor, again, I don't represent First Energy here. My understanding is that the materials there are regarding activity in Ohio involving Ohio employees of First Energy, regarding Ohio activity. Not, Potomac Edison did not participate in any way whatsoever. In fact, we confirmed for OPC that there are no allegations of wrongdoing or any improper behavior by Potomac Edison employees whatsoever.
So the company represented to the commission that this document was, and I'll use the words that Mr. Cleaver used earlier, something that we could trust. So that would suggest that Potomac Edison in some way has reviewed this document, or at least reviewed this in the results of the investigation.
Your Honor, if I
Suggesting
may,
that hasn't happened?
if I may, what we specifically said in our letter in June was Potomac Edison, learning about this investigation, determined that $38,000 had been misallocated. And we went on to say, we didn't say take our word for it, you can trust us. That's not what we said. Look at the June 5th letter. What we said is that we took a proactive approach and that the company will discuss this in the new distribution rate case established in 2023, a base rate proceeding, where the regulatory liability that it has identified will be presented to the commission for review and testimony and afforded parties the right to review those amounts. We did not tell you go trust an investigation by First Energy. We said we identified the amount that had been, Potomac Edison, the amount that had been allocated to us was $38,000, and we will discuss that and be subject to discovery in the upcoming rate case. So that's OPC's characterization of what we said in June 5th. That is not what we said in June 5th. You could go back and look at it. And we wouldn't want you, we wouldn't want you to say, oh, just go trust what happened out in Ohio. This is rate would be in ratepayers' rates. So that will be the subject of a rate case in which the parties will be able to kick the tires on our averments and our analysis.
Your Honor, let me add just one additional point. We made a statement of fact in the June letter that there was an internal investigation done by First Energy. That was a matter of public record. Okay. All we were saying was what everyone in the world already knew because First Energy had announced it to the world that they'd done an internal investigation. The world has now seen the results of the internal investigation, in that there is a deferred prosecution agreement, which also is a document of public record, also is a document that the Office of People's Counsel has between the Department of Justice and First Energy. Okay, so there was an investigation. It resulted in the DPA. Those are facts. The commission, we told the commission the first fact in June, and now the second fact is known to everybody because it's a matter of public record. The commission can be made aware of those facts without being asked to rely on them. And we are not asking anybody to rely on anything. We did our own analysis that's represented in the data request responses, including but not limited to the ones that OPC is arguing about this morning, as to what the impact on Maryland customers of all of this bad stuff that happened in Ohio was. That analysis has been made. We've given you everything we got on that. We've already had that discussion this morning. So what OPC is asking for is all of the internal review with counsel between the board of directors of First Energy, which is not subject to the commission's jurisdiction, and the outside counsel of First Energy, so it's also a privileged document of all of the dirty laundry with respect to Ohio. That's not what this case is about. And it's also not anything that the commission had the option of asserting jurisdiction or trying to assert jurisdiction over those things when the commission entertained OPC's original petition. The commission chose to be very focused. What's the monetary impact on Maryland customers of PE? And we've turned out our pockets on that.
Mr. Cleaver, any response?
Actually, yes, Your Honor. Sorry. Your Honor, I think that what we're hearing a lot of statements that are not consistent with the opposition that Potomac Edison filed to our petition for a proceeding. The petition states, or excuse me, Potomac Edison's opposition to OPC's petition states that this independent internal investigation was undertaken by the First Energy Board. In connection with that internal investigation, again, still speaking of the First Energy Board investigation, First Energy identified certain transactions, including vendor services that were improperly classified, misallocated, or lacked proper documentation. It then says, I'm going to just do two more sentences. In some cases, these transactions resulted in certain amounts being included in customer rates. Potomac Edison has identified less than $38,000 of such improperly classified or inadequately documented funds. So that's Potomac Edison has tied this to it, the matter that we were talking about previously with the $38,000, this internal investigation. Beyond that, Your Honor, if you turn to the next page of Potomac Edison's June 9th opposition to the petition, and there's a sub-item 12, and one of the issues that OPC asked the commission to set for hearing. And the issue that OPC presented in its petition was whether the commission should order an audit of transactions between First Energy and Potomac Edison to determine the extent to which Potomac Edison has been funding activities that involve or relate to the alleged racketeering conspiracy. In response to that specific recommendation, Potomac Edison says, for the reasons discussed in items 10 and 11 above, no audit is warranted. Item 10 is the discussion of the internal investigation. So Potomac Edison most certainly put this issue, this investigation before the commission in an effort to stop OPC's request for a petition.
Your Honor, I'd remind.
May I'm not finished. Mr. Kern, could you?
Continue, Mr. Cleaver.
Thank you, Your Honor. One of the extent to which Potomac Edison goes to try to prevent OPC from reviewing this document, which Potomac Edison injected, and reviewing the information surrounding this investigation, which Potomac Edison injected into this case, are really remarkable. First of all, Potomac Edison says that this investigation exceeds the scope of this proceeding. And I think I heard Mr. Curran say something along those lines earlier. He said this case is about Potomac Edison, not First Energy. This case is precisely about First Energy. That's what this is about. It's about First Energy's conduct and whether that conduct will harm Maryland ratepayers. To say that is disingenuous. You know, Your Honor, as for, and I would also note, Your Honor, that the commission had this matter before it when it set the issue of the payments to ratepayers for discovery in this proceeding. And it saw what Potomac Edison said in this regard, and it still set that for discovery. So the explanation that Potomac Edison gave was insufficient. The second objection is that the commission doesn't have jurisdiction over First Energy. Again, Potomac Edison is the one that has brought First Energy repeatedly into this investigation, as it understandably would, because this investigation is about the conduct of First Energy and how it's hurt Potomac Edison. Your Honor, specifically, when OPC has asked other questions about this investigation, we've gotten answers from First Energy employees. So other questions that aren't the subject of this motion, we've asked certain questions about the investigation. I believe OPC 1.3, 1.4 are a couple examples. We've gotten answers sponsored by First Energy employees. So Potomac Edison is holding this out and telling the commission to deny our petition because of its existence. Potomac Edison's holding it out as evidence that Potomac Edison ratepayers weren't really harmed. When we ask certain questions about it, we're given responses from First Energy employees, but then they say it's not in our control and it's beyond the scope of the proceeding. That's just simply wrong, Your Honor. As for the attorney-client piece, 2 points on that. I would note that in its opposition to our motion to compel, which was just filed on Monday, the November 1st filing, on page 7, there are contradictory statements as to who did this investigation. At one point, it says that it was conducted by First Energy's counsel. But at another point, it says it was conducted by a committee of independent members of the First Energy board. So it says two different things on page 7 of the same response as to who conducted this investigation. That again, Potomac Edison has injected into this proceeding. As for the possession argument, that is just untenable. As Your Honor points out, Potomac Edison talks about this in its filing. It holds it up as evidence for the commission to deny the request for a proceeding in the first place. I know my opposing counsel pretty well, and I trust that I know that they're not going to talk about a document in a pleading filed with this commission that they've never seen. Beyond that, Your Honor, the doctrine of practical availability, which we've cited in our papers, the Fourth Circuit recognized this. Maryland, federal district courts in Maryland recognize this doctrine. We've cited support for that, the Goodman case. In an effort to overcome that, since this is interesting, in its opposition to our motion to compel that it filed on Monday, Potomac Edison cites the case of Steel Software versus DataQuick. That's at 237 FRD 561, District of Maryland, 2006. This is from Potomac Edison's paper, and it says that it says that courts are able to disregard corporate form to prevent misleading actions whereby corporations try to hide documents or make discovery of them difficult. Factors a party must show to establish control include non-party's connection to the transaction at issue in the litigation. That box is checked here. Common relationships between a party and its related non-party entity, including any overlap of directors, officers, and employees. We got First Energy employees answering all the discovery in this case, Your Honor. Shared management, the degree to which the parties normally share documents. Again, Potomac Edison is citing this document as a reason to deny the petition, and the degree of a non-party's interest in the outcome of the litigation. I don't think I need to say more about that one. Your Honor, unless we know what specific problems First Energy discovered, there's no way to know whether it's taken the appropriate steps to address them. And to understand what this investigation entailed, which again, I just for the last time I'll say it, which Potomac Edison brought into this proceeding and told the commission, nothing to see here. We've done an internal investigation. For Potomac Edison, it shows $38,000 in inappropriate funds. But you can't see it, you can't find out anything about the investigation because it's subject to a privilege. The sword and the shield doctrine, which we've also cited, you can't hold out something in defense, but then when someone seeks to understand what it is that you're holding out, you can't then pull it back and say, well, it's privilege, you can't find out about it. It's just highly inequitable to allow a party to do that. The court recognized that in the case we cited in the attorney-client context. The Miles and Stockbridge case. There are other Maryland cases going back that recognize this doctrine as well. So, Your Honor, this is essential to this case. The request is most certainly reasonably calculated to lead to the discovery of admissible evidence, and it's squarely within the scope of the commission's order, and the commission should compel production of the information that we seek in OPC VR 1-2.
Thank you, Mr. Cleaver. So, Mr. Curran, he's making some more pretty good arguments.
Well, he's said an awful lot. I'd like to be able to respond to each piece if I could, Your Honor.
Sure, go ahead.
Well, I mean, Mr. Cleaver just told you what he is after in this case, to expand the investigation beyond what this commission had ordered. The issue here that's relevant at all to this DR is funds of Potomac Edison, right? And we provided all of that information, all of that. He's rambled on a bit, and quite frankly, I don't like being called disingenuous because the commission itself, in its order, described what its jurisdiction was over First Energy. Described in your order that it's limited to compliance with the merger from 2010. Those aren't my words, Your Honor. Those are the commission's words. He wants to expand the investigation beyond how funds of Potomac Edison were being used. It is not about what, as Mr. Cleaver described, what First Energy is doing to clean its house up in Ohio. That's not what your Honor's ordered. That's not what this case is about. And that's what Mr. Cleaver wants to turn this case into. He says that, well, because some First Energy Services Corporation, some shared service corporation employees assisted us in our discovery responses, somehow extrapolates to that those folks have control over the board materials of the parent corporation is a bit of a stretch. The folks that assisted us were First Energy Services Corp employees, just like Exelon has a Services Corp and allocate folks down to BG&E and Pepco, et cetera. First Energy has a Services Corp that allocates folks time and attention to its 10 different distribution companies. That doesn't somehow suggest that those people who helped us in providing answers to Mr. Cleaver, somehow they can extend their control to the First Energy parent corporation and its board of directors. There is absolutely zero support for that contention. They're claiming that we have waived attorney-client privilege. Let's to this document. Potomac Edison cannot waive another person's or entity's attorney-client privilege. Can't do it. And they cite to no law that says Potomac Edison can waive First Energy's privileges because there is zero law for that proposition. They say, well, we have practical control over these documents. We have no legal, Potomac Edison has no legal control over an investigation of employees of the parent corporation. Zero. They establish zero precedent for the idea, and it's their burden, Your Honor. They have to establish that Potomac Edison can somehow reach into the First Energy Board of Directors and have control over materials related to Ohio employees, right? They have established zero nexus between Potomac Edison and these Ohio employees. So that is a bit of a strained argument. No, they have the burden to establish we have control. They haven't met it. They have the burden to establish relevancy to the question of funds of Potomac Edison. They have established zero relevancy of how Ohio employees have anything to do with funds of Potomac Edison, other than what we have provided already in discovery through 1-1 and our fulsome amount of other discovery responses. So that is a bit of a strained interpretation as well. But most importantly, Your Honor, this is privileged materials. There wasn't any conflict in any of our statements between whether the investigation was run by the board of directors or outside counsel. It was a board of directors committee who were advised by outside counsel. And it's those outside counsel materials that are privileged and are protected by law from discovery. Mr. Cleaver's suggestion that there aren't is a bit of a stretch. Now, final point is, and this is repeating a statement from Mr. Trout as well. They're somehow claiming this a violation of the sword and shield principle. That would be true in the context where an attorney is sued by his client, and then the client that the attorney can't use his advice in his defense. We're not asking the commission to put its imprimatur or to approve an investigation of Ohio employees. We've never asked that. What we said is, we've done that. Potomac Edison's done its own investigation. It's determined that $38,000 should not be in customers' rates, and they're willing and ready to defend that and provide the refund to the customers in the next rate case. And at that time, folks can ask all the questions they want about $38,000. But it is improper for what they're asking you to do would be improper, Your Honor. Asking you to divulge and compel the production of the work product of First Energy's counsel in Ohio. That period, that's the end of story there.
So, Mr. Curran, let me just clarify something. And you just said a moment ago that Potomac Edison conducted its own investigation to determine that the $38,000 was improperly allocated. Are you suggesting then that there were two investigations conducted? One by Potomac Edison, separate from the one conducted by First Energy?
There was an investigation, which is the subject of DR 1-1, in which Mr. Valdez determined which of the vendor services that had been allocated from First Energy Services Corp to Potomac Edison were in rates. Yes, that's what he has conducted. And they have provided that response in OPC DR 1-1.
So is it fair to say then that the First Energy holding company investigation reached the same result? Is that what you're saying?
No, I have no idea what result. All we know is what vendors services that were advised remain aware to Potomac Edison. But the scope of the First Energy investigation was of Ohio activity of Ohio employees. That's all that I know. I have not reviewed that other than to know that it's conducted by their board under their counsel. Let's see if Mr. Trout may have more to add.
Yeah, I would just add one thing, and like Mr. Kern, I am not a counsel to First Energy with respect to that investigation. I've not seen the investigation report. But in an effort to resolve this discovery dispute, we did ask, is there anything about Potomac Edison or Maryland? So that's the question Your Honor asked. Were there two different investigations of Maryland? There's only been one investigation of Maryland. That's the one that was led by Mr. Valdez, and that we have, I think I've said now 3 times, turned out our pockets. It is our understanding, Mr. Kern and I, that there is nothing in the document or documents that Mr. Cleaver is insisting that they must see about Ohio. There's nothing about Potomac Edison or Maryland. That's our understanding. And so all that they are asking for, what they are asking for, and Mr. Cleaver basically gave the show away. He said they want to make sure First Energy is now doing the right thing. Okay? Well, that's not what this case is about. This case is about Potomac impacts on Potomac Edison. Okay? There's nothing in those documents, it's our understanding, nothing in those documents that would be probative of that. What is probative of the impacts on Maryland is the investigation as to how much money for those improperly allocated accounts actually hit the bottom line for Maryland ratepayers. And we've given them everything on that. And then we gave them every allocation. And then we gave them every payment. So, it's not a Potomac Edison document. It's a privileged investigation conducted by counsel for the Board of Directors of Energy, and it's not relevant. And all it's going to do is satisfy OPC's desire to try to regulate First Energy's conduct. And the commission at the very outset of this proceeding said that's not what this case is about.
Your Honor, I know you've heard a lot of back and forth, but may I please briefly be heard on a couple of those discrete points?
Sure, very briefly, Mr. Cleaver.
Yes, thank you, I understand. Your Honor, on this point about privilege, Mr. Curran made the statement that Potomac Edison can't waive the privilege. And if it's true that Potomac Edison can't waive the privilege, that means that Potomac Edison is not the client. But Mr. Trout and Mr. Trout most specifically is talking about what his understanding is of what is and is not in these documents. So to the extent that Mr. Trout, as a Potomac Edison lawyer and employee, has been told what is and is not in these documents, any privilege that exists has been waived. They just said they can't waive the privilege. They're not the client, but yet somebody's telling them what's in the documents that they're then using to try to defeat an investigation here. The commission can't let that stand. Also, as to your honors I didn't hear a very entirely clear answer to your honor's question. Your honor asked about were there two investigations, and it sounds, when you read I didn't hear a clear answer, but when you look at Potomac Edison's opposition to our petition, Potomac Edison links the $38,000 investigation, so to speak, to the FE internal investigation. They say that they say the FE internal investigation revealed certain transactions that were problematic for the language we've already read, and it says that Potomac Edison's identified this amount of such transactions, and they also just revealed that investigation was conducted by Ray Valdez, who's a First Energy employee. So First Energy does an internal investigation, and Mr. Valdez, in some way connected to that, has made this $38,000 determination, a First Energy employee. And yet now Potomac Edison's position is that the $38,000 investigation, there's really nothing more to say about what we've said, and you can't find out anything about the internal investigation that we cited and that we told the commission was a basis to deny the request, OPC's request for an audit of all costs. I have other points, Your Honor, but I know you're probably eager to move on, so with that, I'll conclude. Thank you for the indulgence.
Thank you, Mr. Cleaver. Yeah, I have to admit that this one, of all the data requests that were in front of us, this one seemed to be the strangest in terms of how it's become such a larger issue. I would have thought that this document rather would have been made available simply because the company had relied on it as part of their initial response to OPC's investigation request. And I still think that's the case. I am a little concerned about the possibility that there's some privilege attached to it. So I'll ask Mr. Curran, is this a document that, or is this investigation something that you're able to present for a review by me?
I don't believe so, Your Honor. This is First Energy's documents. These are not Potomac Edison's documents. We're not relying on them. They're regarding Ohio employees.
So there's no I'll call it a list of the material or information that's in the report, like a table of contents or something.
No idea. We have no idea if there's a table of contents.
So what about the sections of the report that are referencing, well, let me ask a different way. Are there sections of this report that reference Maryland and Potomac Edison specifically?
And in an effort to resolve this dispute, Mr. Curran and I asked counsel for First Energy that question. We were told there is not. And that is why we find this so frustrating, because again, they're asking for, if what they're asking for is material about Maryland or Potomac Edison, there isn't any. That's our understanding.
I think I'll tell you that I'm kind of in the middle on this one, but I do think that the document is relevant simply because the company has provided it and raised it as an issue. But I'm having some difficulty understanding if there's one or two documents. There's an investigation for Potomac Edison and one for First Energy. So I'm not even entirely sure which one was referenced now as part of the company's response. If you're telling me that the one that was provided was produced by First Energy doesn't reference Potomac Edison, I kind of find that hard to believe, since it is a document that's supposed to reference all of, I would assume represents all of the holding companies, and would investigate and review information about all of them.
So I thought we were clear, and I didn't understand why Mr. Cleaver said there was confusion. There was an investigation conducted in Ohio with respect to what happened in Ohio by the council to First Energy, and at the direction and for the purposes of the board of directors, a particular committee of the board of directors of First Energy.
And so
Separate and apart from that, there was.
Let me stop you there for a second, Mr.
Sure.
Trout. Is that the document that was referenced in the company's response to OPC's request for an investigation?
There are two documents referenced in our response to the petition. The first was, we said, and because it was a matter of public record, we could say that there was such an investigation. And then if you look at, where's the line? I think it's okay. So then there is a separate inquiry. Potomac Edison has identified less than $38,000 of such improperly classified or inadequately documented funds. This is on page 9 of the letter of June 9th to the commission. So that's the second investigation, if you will, if you want to call these investigations, call this an investigation. That was a separate inquiry that was led by Mr. Valdez, figured out that for all the for all the vendors where the accounts that shouldn't have been allocated to First Energy, from First Energy to Potomac Edison. When you did all the math and all the calculations which are set forth in the response to OPC 1.1, you came up with the $38,000 impact, or $37,000 and change. And so that's, if there's confusion about if there's one investigation or two, I would say there are two. One is about Ohio, all the bad stuff that happened in Ohio, that was done in Ohio by First Energy with First Energy's counsel. And then there's what Mr. Valdez did or led the analysis that came up with the $38,000 and that we referenced in the letter of June 9th. And that we have, this is now the fourth time I've said it, but it apparently bears repeating, we've turned out our pockets on. So what Mr. Cleaver is asking you for is all of the internal privileged First Energy third-party investigation of all the bad stuff that happened in Ohio and that has nothing to do with Maryland. Well, that the only spillover into Maryland, Mr. Valdez determined, was $38,000. And you've got the second part of that already. And respectfully, Your Honor, we do not believe that OPC is entitled to the first.
So, Mr. Cleaver, you thought you were finished, but I have one more question for you. Were you under the understanding that there were effectively two investigations, and the company was relying on the second one from Potomac Edison? What was your understanding?
That my understanding, again, based on the Potomac Edison opposition to the petition that OPC filed for a proceeding. My understanding, and I think it's based on the plain language, is that there was First Energy undertook an internal investigation in connection with what happened. As part of that investigation, and this is directly from the response, as part of that investigation, First Energy determined that there were certain transactions that were, inappropriate. There's the three terms that are either properly out. I can read the language, but that were misallocated. Bear with me a second, Your Honor. I can. Certain transactions, including vendor services that were either improperly classified, misallocated, or lacked proper supporting documentation. That realization and determination came out of the First Energy internal investigation. And then connected to that, Potomac Edison identified $38,000 of such transactions. These are linked. The internal investigation, and this is not my interpretation or my argument, this is what the response says. The internal investigation from First Energy included that determination about the improper charges. And then linked to that, Potomac Edison, through a First Energy employee, Ray Valdez, determined that Maryland only paid $38,000.
So you understood this to be one investigation partially conducted by Potomac Edison and partially conducted by First Energy.
I think the whole thing was conducted. The whole thing was conducted by First Energy. Mr. Valdez is a First Energy employee, and when we asked I hate to backtrack. When we asked in 1-1 who was involved in this analysis, we got the names of 3 First Energy employees. So there was no Potomac Edison investigation that a Potomac Edison employee led. There was a First Energy internal investigation, and then there's a statement that Potomac Edison determined, but it's a little strange because it was 3 First Energy employees that were in charge of this, but it says in connection with that, Potomac Edison determined that there were $38,000 in such transactions. So it's all part of the same analysis, and respecting what Your Honor said about 1-1 and the company's statement that it didn't have anything else to give, we're left right now with, regardless of whether it's, you can consider it all one large investigation and the 38K is an extension of the big one, or whether it's somebody said, all right, this one's over, tomorrow let's start this one about Potomac Edison. Regardless of whether it's one big thing or two investigations that are related, the fact of the matter is that we don't understand anything about it based on the information that the company's refusing to provide. Again, we have the names of 3 First Energy people. We know it involves allocated costs, which is obvious. We've seen a spreadsheet with some ledgers that show payments to Ohio entities. That's it. That's all we know about any of it. And in order for us, this is similar to some things I said in response in the 1-1 discussion, but in order for us to understand what has happened and to understand and make sure that Maryland customers are protected. And by the way, Your Honor, we're not interested in salacious details. At this point, we have very little interest in which executive texted which regulator or politician. We want to protect Maryland customers. And we want to make sure that Maryland customers are made whole from any harm they suffered and are protected going forward to make sure this doesn't happen again. And that investigation, again, was held up for this commission as a basis that an audit of all the costs was not necessary.
Thank you, Mr. Cleaver. I think I've heard enough. I'm going to grant the People's Council's request. I'm not sure really what the distinguishing feature is between the 2 different investigations. And so when I look at the responses that have been provided by Potomac Edison, it doesn't make entirely clear to me that there was a separate investigation. And so, at least from the responses that have been provided as part of the filings. So I think there's more to tell here that hasn't been provided to the company. To the People's Council. And okay, we're getting very enthusiastic. I mean, totally, court reporter needs a break. So, any questions on that?
We need a clear ruling from Your Honor on how you're ruling on privilege in this case. This is a privileged document. We need a ruling from you on that issue. And we need a ruling on you on control.
Which is the privileged document?
You're asking for Potomac Edison to turn over an internal investigation of First Energy's that was conducted by their counsel. That's a privileged document. We need a ruling from the bench as to your ruling on that issue.
I personally think that the company, on several occasions here, and I think People's Council has made a pretty good argument here that to the extent there was a privilege there, a couple of instances the companies raised it a couple of times here as an example of why the commission initially did not need to proceed with an audit of the company. There's some question now as to whether or not there was one investigation or 2. So I think the People's Council has made a strong argument that they don't have all of the answers to the data requests that they've sought. I'm looking at the 4 questions here. They have been referencing an internal investigation. And we've been hearing today that there's a potential of 2 internal investigations. So are you suggesting that the Potomac Edison investigation is confidential or is it privileged?
We have not asserted privilege over the Potomac Edison materials, and they have been provided to OPC. The materials of First Energy conducted by their counsel are privileged materials. And that's what OPC is seeking in its motion to compel.
So yeah, I'm still convinced that the company has Potomac Edison has waived that privilege. You certainly
Your
provided it
Honor,
numerous times to the. You referenced it here multiple times.
a public fact has been referenced. The report itself has not been provided to any regulatory body. The report itself is a privileged document. It is the fact that it's been referenced and does not waive the content of the document. And certainly Potomac Edison can't waive the privilege of its parent corporation.
Thank you. Thank you for the argument, Mr. Curran. I appreciate it. Is there anything further?
No, Your Honor, we're ready to address the data request 110 at Your Honor's pleasure.
So I've been informed that the court reporter needs a break, so we're going to take a 10-minute recess. It's 12:41. We will return at 12:51, and we'll continue with item 1-10.
Thank you, Your Honor.
We are back.
Yes, Commissioner.
Commissioner, very quickly, I inadvertently did a screen share. I will clean that up from the recording later. Hopefully nobody had a chance to actually read anything.
It was very quick.
My apologies. I thought it was a G chat that would pop up on my other screen. I'll fix it.
So we're Madam Court Reporter,
Yes, Commissioner, thank you.
are you all ready to go?
Yes, sir.
Okay, great. Let's go back on the record. And we will continue on with the different discovery requests from OPC. We'll continue on with item number 1-10.
Yes. Hi, Your Honor. Thank you. For some reason, our video feed is not coming on. We're trying to figure it out. Apologize. If you could just bear with us for a second.
Sure.
It's the same setup we were just using, and we didn't change anything, so we don't really understand.
Okay. We'll go back off the record until People's Counsel is ready to proceed. Just so that the parties know.
Your Honor, we're going to drop out of the meeting and come back to try to see if that fixes it.
Okay.
Thank you. Can you?
Won't make any decisions while you're gone.
Okay, it looks like we're working again, Your Honor. I apologize for that. Okay. Should I proceed now?
Yes, let's go back on the record. You can proceed, Mr. Cleveland.
Thank you, Your Honor. The next data request that's the subject of the motion to compel is OPC request 110 to Potomac Edison. This question falls within that last area of inquiry that the commission established for this docket regarding whether the ICON agreement may potentially provide for substantial influence, may potentially provide the ability to exercise substantial influence over Potomac Edison. And the question asks for drafts of agreements between ICON and First Energy. I think that key to this is remembering that when the commission granted OPC's petition in part, it already had before it the ICON agreement. That was filed with the commission on March 31st, and it was discussed extensively in OPC's petition and Potomac Edison's response and in our reply. The agreement contains a provision stating that the ICON board members agree that they will not exercise or take any action that would constitute exercising substantial influence or control over the company or any of its subsidiaries. That's at section 1A Romanet 2. And as I mentioned at the outset today, the commission's never had before it, that I'm aware of, an agreement that sought to take an agreement outside of the scope of the statute by including the mirror image language that says that the triggering event of the statute is not going to happen. And again, the PSC knew about this language when it granted the petition, and it allowed OPC to ask discovery on substantial influence. So notwithstanding the language, the commission concluded there's at least the possibility of substantial influence. And OPC has, with its questions that it asked of Potomac Edison, has endeavored to understand what the provision means. And that's consistent with the commission's apparent conclusion that the provision was not as dispositive as it may have been designed to be. Beyond that language, the ICON agreement also grants ICON's two designees 2 board seats, so the board seats would go from 12 to 14, and also rights that no other board members enjoy, including that the board cannot form any new executive committees without approval of both ICON designees, and also if any non-executive committees are formed, at least one ICON designee must be given a seat on the committee. In asking for the drafts of the agreement that were exchanged, that's a straightforward way to investigate the subject that the commission set aside, to try to understand these terms and what they mean and why these designees were given these rights, and what the understanding is for the parties as to what those rights entail and what this language is supposed to mean. What does it mean that the ICON designees won't exercise substantial influence? I mean, this commission has determined in the EDF case that a board seat can create the ability to exercise substantial influence. So what is it about these 2 board seats that we know have a heightened set of rights associated with them that apparently, based on this in this language, won't give them the right to exercise that? We want to understand what that means, and the best and most straightforward way to do that is to understand what the parties exchanged leading up to the agreement. Potomac Edison objects to the request. It objects on the basis that the extent that it exceeds the scope of what was set by the commission. And that's a non-starter. I mean, it just doesn't go anywhere. The commission set whether this agreement may potentially give rise to substantial influence is one of the 3 areas where discovery was permitted. It's squarely within the scope. PE also objects that it requires the disclosure of attorney work product, privilege in communications, legal advice, or other communications protected from disclosure, which is not a recognized objection or privilege that I've ever seen. So I don't know what that, I'm not even sure what that means. And then the third ground is, but PE says that it'll provide responsive non-privileged document. Again, we hear about in the response, PE says it's investigating Potomac Edison, not First Energy. But again, what the commission set aside for hearing is, or for discovery rather, is the extent to which this agreement could give rise to ICON designees exercising substantial influence over Potomac Edison, which would only occur through their position on the First Energy board. So First Energy is at the center of this analysis, as is any acquiring company in any 6105 case. In all the 6105 cases before the commission, the applicants, so to speak, are the acquiring company, the company that will acquire the substantial influence, and the acquired company, the public service company. That company is always at the center of this. So to argue that this that this is not about First Energy is just misplaced. Potomac Edison also cites a bench ruling from 9271, the 2012 merger case involving the Exelon Constellation merger. But that's not what we're talking about. What was at issue there? What was at issue there was a settlement that had been reached between 2 parties in a litigated case presently pending before the commission, and someone sought to discover, the settlement negotiations, and the commission deemed that inappropriate. That's not the case here. Here, the question is whether the terms of this agreement provide rights that amount to substantial influence. We need discovery to evaluate the scope of those rights. More on point to this discussion, as opposed to the 9271 bench ruling that Potomac Edison cites, is an order from case 9631, the Exelon PHI transaction, order 86661. And there, the applicants sought to, let me say this, the applicants objected to a request from the commission's technical staff to produce an unredacted copy of the Hart-Scott-Rodino filing. And the technical staff said that it needed the information it wanted to evaluate all the bidders for PHI. And the applicants took the position that you don't need to know this. The transaction before you is the is the Exelon PHI transaction, and we don't need to get into this. And the commission granted staff's motion to compel that it ultimately filed. And the first reason that the commission gave for granting the motion is the language in section 6105F6, which says, F says, application for authorization. An application for authorization under subsection E, which is the part requiring commission approval, must include detailed information regarding all documents relating to the transaction giving rise to the application. All documents relating to the transaction giving rise to the application. That was what the commission cited in granting staff's motion to compel. The commission also mentioned that in response to this argument that was raised in that case about, well, you have a transaction before you and that's all you can review and you can't pull back the curtain, so to speak. The commission said that subsection G2 Romanet 12, which is the catch-all for all the factors the commission is to consider, is very broad. And the commission isn't constrained as to what factors it can consider. So
Thank
that
you.
ruling there.
Thank you, Mr. Cleaver. Thank you for that. And I don't mean to interrupt, but I'm really more interested in the People's Council's arguments as to why they need additional information. Well, I guess a more supplementary response from the company regarding the ICANN agreement. So if you could focus on that, I appreciate it.
Sure, I understand, Your Honor. Thank you. Your Honor, we've all seen the agreement, and we all know what it says, and we've had it for quite a while. We've had it since before the commission entered the order establishing this proceeding. But the commission nonetheless determined that it was appropriate to conduct discovery on whether that agreement may potentially provide the ICOM designees with the ability to exercise substantial influence. So that in order to get to that question, that precise question, which the commission found appropriate to look beyond the four corners of the agreement, the best way to understand that is, what is the understanding of the parties? How did we get here? The agreement says what it says, but the commission knew what the agreement said when it ruled that discovery was appropriate. So the most straightforward way to get to the most straightforward way to get to that understanding and to gain insight into why these very unusual provisions were offered, which appear to give these designees uncommon rights. The most straightforward way to do that is to understand and to be able to assess what those rights mean. And what we've asked in 110 is, in our mind, the most direct and clearest way to do that.
Thank you, Mr. Cleaver. So, Mr. Curran, do you have any response?
I do, Your Honor. If Mr. Cleaver is interested in the meaning of the terms, those are in the agreement itself. The commission does not, nor have they ever granted a request for the drafts of an agreement. The agreement speaks for itself. The terms are in the agreement, and those are the ones that are effectual, not the drafts. This commission itself, just a few years back in the Exelon Constellation merger, EDF asked the same questions that OPC is asking here. We need to understand and kick the tires on an agreement between the state of Maryland and Exelon. We need to look at the back and forth, the communications between the governor's office, and we need to look at what he was concerned about in order for us to understand the terms of the settlement. And the commission, rightfully, as they should do here, said, no, you're not entitled to the back and forth in a settlement discussion between parties. Those are protected by the Federal Rule 408, and they're protected by this commission's precedent that you would be putting a chill on settlement negotiations if we were to be able to have a third party come in and look at those communications back and forth. And that's what OPC is asking for here. OPC is asking for the back and forth between the Icon Group and First Energy, which is of no relevance because the only relevance is the agreement itself. And the question would ultimately be for the commission is, does that agreement create rights in the Icon Group that would give them substantial influence over Potomac Edison? Not drafts of the agreement. The drafts of the agreement are irrelevant. And I've been involved with a number of 6105 cases, Your Honor. Mr. Cleaver cited to a provision of the 6105 statute, which quite frankly is not an issue here because there is no 6105 application, but he did cite to 6105 in the fact that there's an obligation of the applicants to provide a copy of all the agreements, right? I've never been involved in a case where the commission required drafts of the merger agreement because they're irrelevant. It doesn't matter what the draft says. What matters is what the merger agreement says. And we don't even have a merger here. We have a settlement agreement between the Icon Group and First Energy in order to resolve a proxy contest. So we haven't even gotten to the point where there is a 6105 case in order for the statute to kick in. But the commission has never required communications between settling parties. Such an idea would put a chilling effect on any settlement if those sort of communications were required to be disclosed. But getting to his central point was, hey, how does OPC know what any of this means? The meaning of the words are in the document. You don't need the communications between the parties to give them effect. The document is what gives it effect. There's no parole evidence here. There's no dispute over the meanings of those words. The words mean what they mean. So the idea that we would be required to disclose those, or that, I don't even say Potomac Edison, because these aren't even Potomac Edison's communications, Your Honor. As I repeated earlier, these are communications between Mr. Icon, who is not Potomac Edison, and communications with First Energy, which is not Potomac Edison. So I really don't see how we could compel the production of those. The commission has been made aware of the agreement that it gives Mr. Icon the Icon Group 2 board seats. Since that time, the Potomac Edison board has grown. It's not just 14, it's 16 members. So the Exelon board just grew, and a new member. Is it OPC's position that anytime a new board member comes on a parent corporation that we have to run in and have a 6105 case in front of the commission? No, of course not. That would be ridiculous. In fact, the statute itself is for acquisitions of energy companies or of utilities. And there has been zero acquisition in this case. Mr. Icon is an existing shareholder, had a dispute with the company and threatened, and there was a potential proxy contest over those concerns, and they were resolved. And we want to encourage resolutions of disputes. It was resolved through the development of the nomination agreement, which was provided to the commission as information. We were not asking the commission to approve that. And in discovery here, the commission has asked and provided OPC the ability to conduct discovery in which we have provided them a number of answers. The legitimate questions they asked were about obtaining copies of our bylaws and other legal governance agreements that would give them some insight into whether, based on our bylaws, based on our corporate governance information, whether or not those board seats could result in the ability to exercise substantial influence, which, as Your Honor knows, is a legal question. Is a legal question of whether someone can exercise substantial influence. So that's why we have provided the legal documents to OPC to give them insight into whether or not that can be exercised. What you shouldn't do, Your Honor, and what you've never done before, is required settlement communications between parties. You would be putting a chilling effect on those communications. There's one other thing I do want to mention. Mr. Cleaver had referenced the fact that, well, this is not a settlement because it wasn't a settlement before the commission. That is of no effect. Rule 408 of the federal rules protects settlement communications between parties in order to resolve a dispute. For instance, if BG&E had a dispute with the city of Baltimore over its conduits, right? And there was a dispute back and forth, and they amicably resolved that. And then the BG&E came before the commission and in a rate case and discussed what their costs are for conduits. The commission doesn't turn around and then compel discovery of settlement communications between the city of Baltimore and BG&E. What they would compel is the ultimate resolution of those settlement discussions, which would be the agreement. And that's exactly what happened here. There was a conflict between the Icon Group and First Energy over a proxy issue. It was resolved to both parties' benefits. It was resolved amicably, and we've made the commission aware of that. But again, you should follow the commission's precedent, which has never permitted required settlement communications to be disclosed, and you should follow the commission's precedent of not requiring drafts of documents which are of no relevance to be produced.
Thank you, Mr. Curran. Sorry.
I'm sorry, Your Honor. I didn't mean to cut you off. If I could be given an opportunity to quickly address some of those points, I'd appreciate it.
Yeah, very briefly, Mr. Curran.
Thank you. Your Honor, again, I heard Mr. Curran say that the agreement speaks for itself and that the only relevance is the agreement itself. Those were both comments he made. Both of those comments are in direct conflict with the commission's order, saying that discovery was appropriate to determine. The commission had the agreement. The parties had the agreement. Mr. Curran mentions the EDF case and says there was a settlement with the state of Maryland and parties were trying to understand what happened. State of Maryland is not a target company under 6105 as compared to a utility. That's what triggers 6105. That's what triggers the commission's jurisdiction. That's why the commission has authority over these cases, because of its regulation of public service companies. And Mr. Curran cited Federal Rule of Evidence 408. That's about, you can't dispute, if someone disputes a debt in a litigated case, you can't say, why'd you offer to settle it for $10 last week? Obviously, that would chill settlement. That is not at all what's going on here. That's specifically what the rule addresses expressly. I would say just a few more very quick points. This is a very unusual case with a 6105 angle, because typically with the 6105 cases, I know there was the EDF case, which is one exception, but typically with 6105 cases, two companies come and they file an application and they say, we want approval under 6105. There's no threshold issue of does 6105 apply, which we have here. So this is not the typical 6105 case. And that brings me to my final point in response to Mr. Curran. He said, we haven't even gotten to a 6105 case yet. That's correct. That's the point exactly. That's why in order to determine 6105 applies, based in, again, and in light of what the commission has said and what we had before the commission made that, we need to try to understand what this agreement's purpose is and and how it works and its operative level. Yes, we have the agreement, but and again, the commission agreed that's not enough. This, especially for an agreement that, as Mr. Curran just revealed, it came from this whole thing springs out of a proxy contest argument. As we had you've got someone who's known nationally, globally as a quote corporate raider who's in a proxy contest with one of our utilities as owner, and they settle it through this very unusual board assignment with these heightened rights, and that tries to disavow the statutory language. We need to understand that, and this is what we've asked is the most straightforward way to get there. Thank you, Your Honor. I appreciate that.
Thank you, Mr. Cleaver. So I have a couple of questions for PE. You stated that these the documents and the materials that the People's Council is seeking were discussions between First Energy, or the board of First Energy, and the ICON group. I'll just reference them generally as the ICON group. Is Potomac Edison either engaged in or in possession of any of those communications or materials?
No,
Do we know if those materials either referenced or were in response to the need to work around 6105 and Potomac Edison in general, and the merger agreement between Potomac Edison and, excuse me, the acquisition between Potomac Edison by First Energy, or Allegheny Energy by First Energy?
Commissioner Linton, I'm sorry, I did not understand your question. Could you repeat it?
Sure. Were any of those documents related to the need to address the merger conditions in the 6105 merger conditions in the merger case between First Energy and Allegheny Energy?
Were they related to the First? I don't know if they are related in any way to the First Energy Allegheny merger case, Your Honor.
So
but not based on the written words of the document. There's no reference to the First Energy Allegheny merger.
So I actually read the ICON agreement. Doesn't have a great plot, but it's a good read. The document itself, specifically the section that we've been discussing here, related to the substantial influence and the prohibition of it. Can you tell me if it relates to all of the subsidiaries of First Energy? So it doesn't call out Potomac Edison directly. I'm curious if that substantial influence is an issue in Pennsylvania or Ohio or any of the other states where First Energy has utility companies or subsidiaries.
Your Honor, I am not conversant on the merger statutes in any of the other jurisdictions in which First Energy utilities operate.
Let me add to that, Your Honor, that, and I am skating way out to the very edge of my knowledge base, but it is my very thin understanding that there is a standard that applies in FERC that, if not worded exactly the same, covers the same waterfront. So, and I, like Mr. Kern, I am not familiar with the rules in Ohio or in Pennsylvania or New Jersey. I am familiar with the rules in Virginia, and there is a standard in Virginia that, again, covers, it's not word for word the same, but it covers the same, some of the same waterfront. If the thrust of your question was, does the language in the merger agreement that OPC is focused on potentially address other jurisdictions than Maryland, the answer would seem to be, from the law of those other jurisdictions, yes.
Okay, that was part of my question. Thank you, Mr. Trout. Was this language crafted specifically for Potomac Edison or for all of your subsidiaries, all First Energy subsidiaries? And from your answer, it sounds as though it was crafted for all of them and not just Potomac Edison. Is that accurate?
I'm struggling to answer your question because I want to answer your question, without waiving any attorney-client privilege, because we've been accused of waiving attorney-client privilege in this proceeding and indeed in this hearing. It is my understanding that there was one negotiation. Does that help? Does that address your question, Your Honor?
That helps.
Okay.
That helps. Thank you, Mr. Trout. So looking at the four corners of the ICON agreement, are you able to explain to me, or at least to say generally, how the substantial influence prohibition in the document would be enforced?
I would assume that it would be enforced like any other contract provision. If there were a dispute, the parties would discuss the dispute, and if the dispute were not resolved, then whatever remedies apply for an alleged breach of contract would apply. I'm trying to remember, is there an since you've read it more recently than I did, Commissioner, I don't remember if there's an arbitration clause in some of that document.
I didn't see one. There are provisions in it that allow for corrective actions to be taken after 5 days of notice.
Okay. Yeah. So,
but I don't. But I guess for issues like this one related to whether or not a board of directors is exerting substantial influence over one or more subsidiaries, I don't know. I'm not really concerned about the other ones. I'm obviously concerned about Potomac Edison. But,
yeah.
I'm just trying to determine if the request that People's Counsel is making for these background discussions can be answered by the document. I'm not trying to find out if there's a way to get there, but I don't know that there is. But at the same time, I don't. So I can. This one doesn't require a lot more discussion from the parties.
Your Honor, this is not argument. Something that may be helpful to you as the adjudicator here. Just to answer Your Honor's question, and I had actually recalled this from looking at this in a 6105 appeal years ago, and I think it's correct. Ms. Wiggins just checked it out on Westlaw. I think the only state that uses like that same language, and again, there may be states that have a very similar, formulation but that's slightly off. But I think the only state that uses that same language that we have in Maryland is Oregon.
I don't know that First Energy has any subsidiaries there. I do appreciate it.
I don't think so, but just wanted to
I appreciate
it. Your Honor, and with respect to Ms. Wiggins, I am a member of the bar of the state of Virginia. I'm familiar with, among other things, the Utility Transfers Act, the Transfers Act statute in Virginia. And she is correct that the language is not identical, but the concept is there, worded slightly differently. Now, Virginia has percentage thresholds that are helpful. But yeah, so, and then I'm not going to talk about FERC because that's other than a general awareness that there is an issue or a standard in FERC. I don't know what it is, but I do know what the standard is in Virginia.
Thank you. So the commission has already, I think, Mr. Cleaver has correctly acknowledged that the commission had the ICANN agreement when it issued Order 89888, authorizing discovery into the background information here regarding the development the agreement and whether the newly appointed directors could exercise substantial influence. However, I'm also persuaded by the company's argument that a lot of that discussion would not be in Potomac Edison's possession. And having read the document, I know that most likely a large majority of that discussion was probably tied to some of the other terms in there regarding certain board of director rights. So I am going to grant in part and deny in part the People's Council's request. The company can supplement its issued here. I think I see one. So there's been one issue, one response. So you can supplement data request 110 for any additional information regarding Potomac Edison directly, or Potomac Edison, or that's in Potomac Edison's control. Well, that's not what they asked for. So it's tied only to the information about Potomac Edison or under Potomac Edison's control. For the People's Council, if you're interested in revising or sending out a follow-up data request to pursue more information regarding the substantial influence section of the document, that may be they may have probative value, but I think that the request that you've made here for all communications is a bit broad. There certainly would have been communications between the Icon Group and First Energy that are not related to Potomac Edison, simply because the the Icon agreement, includes a number of other terms and conditions that are not under the items and issues that the commission has requested as authorized for discovery.
Thank you, Your Honor. I appreciate that. And just so I'm clear, that the partial grant was any communications that concern Potomac Edison, or any communications or documents in Potomac Edison's possession. Is that?
That's correct.
Okay. Thank you.
All right, thank you.
And now, unfortunately, it's my turn to ask a clarifying question. I assume you mean non-privileged documents, because, for example, if Mr. Curran or I provided legal advice to our client at any point about any of this, that would be that we're not compelled to produce that.
No, I'm not. I wasn't referencing those documents. Certainly, if there are privileged documents of that sort, then you could just identify that in your response, and People's Council can operate appropriately.
Thank you, Your Honor.
Thank you, Your Honor. And may I ask that? Well, let me make a request. Would the company also please provide a privilege log for any privileged documents for any documents that fall within Your Honor's order that it says are privileged?
Were you making a request of me or of the company?
I mean, it's required, but I just was I was just while we're talking about it, and in light of Your Honor's instruction to Potomac Edison, I was wondering if it may be something that the commission that Your Honor would include within your direction If not, I suppose I could write to the company separately and ask for it, which I'm entitled to do. But I just think that maybe the cleanest way to do it is to have Your Honor tell them to do it.
Well, the company has stated that they are willing to work with People's Counsel. And so I don't see very happy faces there on my screen. So I think they would be willing to respond in a way that will help resolve that matter without the commission issuing the direction.
Your Honor, we'll follow our discovery obligations as we always have.
Thank you. All right, let's move to OPC 1-22 regarding First Energy Ford materials.
Yes, thank you, Your Honor. Yes, this question asks Potomac Edison to provide all First Energy Board or committee notes, agendas, presentation of reports to the board subsequent to the execution of the ICON agreement. The reason we seek these materials is simple. We want to see whether and how the ICON directors may be exercising substantial influence. Potomac Edison objects, and it says it exceeds the scope. Again, harkening back to my comments when we were discussing 110, this is squarely within the issue that the commission determined was appropriate for discovery. And even though these designees can't vote, an understanding of an understanding of what they have access to, what they're saying, what they're doing, is critical to evaluating this claim that they won't be able to exercise substantial influence. And I would just add also just briefly, Your Honor, that this of course goes back to the idea that this is a very unusual 6105 analysis in that you don't have two companies that have worked out a transaction and have agreed that 6105 applies and have come to the commission and asked for approval before closing. You've got people that are already presumably attending board meetings. So what better evidence of what these individuals may do or what plans they may have that in terms of the influence they will wield as it relates to the distribution utilities of First Energy than what they're saying and doing now. So that's why we want to obtain this information to carry out that 6105 analysis. Thank you, Your Honor.
Thank you, Mr. Cleaver. Mr. Curran, before you start, I just have a couple of clarification questions so that I'm sure we're on the same page here. The ICON agreement prohibited the new directors from participating in anything until all regulatory approvals were obtained. Has that occurred? And if so, do you know roughly when?
The restrictions are voting.
I know you provide notice to the commission, and obviously you didn't seek regulatory approval here, but there were others that you needed from other administrative bodies.
Your Honor, I don't know. I'm not counsel for FE. My recollection is that the restriction was on voting rights, but I don't know what they are restricted to or not. The question was about obtaining the board materials of First Energy, our parent board, since they had assumed their position, regardless of what restrictions are on it, pending all regulatory results. And we made an inquiry, Your Honor, of the First Energy folks who reviewed those materials. OPC had narrowed its request of us and its email to us of October 6th to materials of the board related to Potomac Edison, related to the ICON agreement, and related to or mentioning the state of Maryland in any way. And we got word back from the board that none of the board materials are related to PE or Maryland or reference the ICON agreement. So all that's remaining is the board materials regarding all of our other 9 utility subsidiaries, which is outside the scope of these proceedings. So that was our agreement with OPC. They were not satisfied when we came back with the answer, Your Honor, but we did do what they asked us to do in order to resolve this discovery dispute, to go back and seek whether or not there was discussion of any of those items. And there are not. So the board materials then would only be about all of the other activities of First Energy and its 9 other utility subsidiaries, which we clearly believe is outside the scope of these proceedings. So I don't know if that answers your question, but that's, other than we did let them know that our understanding is that the board materials note the ICON members' attendance at the meeting. That is the limit of the discussion of the ICON members, the ICON agreement, and Maryland and Potomac Edison.
Thank you, Mr. Curran. So, and you may not know the answer to this question. It's okay if you don't, but do you know how often the board meets, or how many times they've met since March 16th?
I do not.
March of what, Commissioner Linton?
I'm sorry. I'm sorry, Madam Court Reporter. March 16th, 2021.
Okay, thanks.
So thank you, Mr. Curran. So, Mr. Cleaver, the ICON agreement does limit the board directors the rights that you've been discussing earlier, and quite a few of them actually are limited in the document until all regulatory approvals have been established. And so I know that most of those there's actually some that were only recently granted. Are you familiar with whether or not they've all been granted?
Well, Your Honor, just for the record, our OPC's position is that this commission has to approve this transaction, of course, and obviously, of course, it hasn't. So, but beyond this commission, I'm aware of the FERC ruling, which is a very different standard than what this commission has. I don't know the status of anything happening in any other jurisdiction.
I would hope that. Well, I guess that's your position. As I said just a few moments ago, the document limits the rights of the ICAN board members until all regulatory approvals have been established. And if the commission here hasn't granted them, then they wouldn't have been able to exercise any influence because they can't operate on board. But I know that's the position that you stated, that you're not necessarily stating in this case, but the challenge I'm struggling with is that if I'm just asking the question, have they been even on the board yet since the ICAN agreement has been signed, which was just about 6 months ago, give or take?
Your Honor, that's a good point. I mean, I understand it. If they've not been participating because they believe that they need to get the approval of the Maryland Public Service Commission, that'd be music to my ears. That's different than what Mr. Trout said in his letter. He said, the position is that there is no approval required. So there may be some other body that's, where I don't know how you could reach a different conclusion with another state that maybe Mr. Trout or Mr. Curran can offer that, if someone has said it in Pennsylvania or Ohio to the relevant state commission there, approval is required from you. I don't know why that would be different, but and if that's the case and they haven't done anything yet, then yes, Your Honor, you're absolutely right. It's a good point. Then these documents wouldn't reveal any light on their involvement, but I don't know that that's the case. So I guess that's what I'm We don't know that. We've never seen that in any of the responses that say like these guys have been completely kept away from the board because we're waiting for authorizations from state A, B, and C or anything like that.
Well, I'm not suggesting that they haven't attended meetings and things of that sort. What I am suggesting is that to the extent they've had the ability to vote on matters, serve in committees, the kinds of rights that are in the ICANN agreement, those are limited until they have all of the appropriate regulatory approvals. Now, I'm not commenting today on whether or not the commission has to give grants and approval. It's not before me at this point. The point I'm trying to get to is in terms of the question of whether or not this data response needs supplementing in any way, is I'm trying to make sure there's actually something to direct the company to provide. And I'm not entirely convinced at this point that there is. I don't know that the regulatory approvals have been given, and I don't know if the board has even had a meeting. So as a result, if they haven't met and the board members can't participate, then I don't know how they could have had exercised any undue influence. Now, it doesn't necessarily mean that after those things occur in the future, there could be some opportunity. But that's a different data request for a different time and a different discussion. So for purposes of 1-22, I'm not convinced that there's anything here that I can direct the company to provide. So I will grant in part and deny in part. The grant will only be for the company to supplement their data response to item 1-22. Once again, with any information that's under its control. But for any board records or any minutes related to the say the words correctly here, related to OPC data request 1-22. Note that discovery period here ends on, I believe it's the 24th. Is that correct?
I'm sorry, Your Honor, was the question, what's the next data request?
No, the discovery period for this proceeding, is it November? I believe it's November 24th is when it ends.
I believe that the commission's order was issued on July 26th.
26th. It's November. Yes, November 26th is a Friday. Thank you.
And I think that might be the Thanksgiving holiday, so maybe it would be the following Monday. But yeah, around the
following Monday. Thank you. So the company can supplement any information that it may have regarding the ICON. I'm sorry, just in response to OPC 122.
Your Honor, are you asking us, so in the first supplemental response, we said there's no such material. In the second supplemental response, we said there is no such material to us, an additional list of material. Are you asking us to, and so that would have taken us up to October 15th. Are you asking us to continue to
continue that,
determine whether there's anything that has been generated since October 15th that would be responsive to the answers as we've given them?
Yes, and that goes up to, again, I just earlier, I tried to determine if anything could be generated between now and the end of the discovery period. And I don't have the answer to that. So the best I can do is to say that the company will supplement its response up until the day of the discovery period ending.
Thank you, Your Honor. I understand.
All right. So we'll just keep rolling along. We'll take item number 1-24. It's my understanding, Mr. Cleaver, that People's Council has already agreed, or has the people, let me ask the question actually, has the People's Council agreed to narrow this request to documents related to Potomac Edison?
Well, Your Honor,
Or is that, I'm only asking if it's an offer or if it's.
yeah, there's a little bit of a history behind that, and I'll just try to go through it quickly.
Sure.
We tried, in good faith, and I think I'll say again that I appreciate Mr. Trout and Mr. Curran. We had a number of phone calls and letters, and we were able to resolve a lot. So we tried, we know this is taking up a lot of your Honor's time. We did try to resolve it. So one of the ideas that we had for potentially resolving this is, there was a suggestion that if you limit the scope to Maryland and Potomac Edison and reference to those, to the state of Maryland or the company Potomac Edison, then the counsel for Potomac Edison indicated that it would go back to its client and ask if it was willing to agree to that. So that's where it was left in the phone call. And then we said, all right, well, we want to consider it. So we subsequently, Ms. Wiggins wrote a note, an email, and said, we will agree to this in exchange for more information. We'll agree to narrow it. And then the company came back and said, oh, great, but the answer to you is that there is no information. So it was an idea to try to resolve this, that it was conditioned on more information, and then the answer was we don't have any more information. So at this point, I think we're back to where we were with the question, to answer Your Honor's question. And the question seeks copies of all reports, including audits, that address the misconduct, whether conducted by or for FE or PE or any other FE company. And we've gotten a response that these reports are privileged. I mean, an audit report is not a privileged document. And we haven't really seen any explanation of how it could be. Potomac Edison also says, well, they're not in our possession, which is strange. If they know they're privileged, how do they know they're privileged if they're not in their possession? It raises a question. Again, this is kind of like consistent with some of the themes we've heard earlier about control and who controls these documents. But the bottom line, Your Honor, is that in order to understand and confirm how First Energy investigated the extent to which customers of regulated distribution utilities funded the activities that gave rise to the criminal case and gave rise to this petition. In our view, any audits that were performed are highly relevant to that, and would help us to understand that specific issue that the commission carved out. Thank you, Your Honor.
Thank you, Mr. Cleaver. So let me just be clear then. The company's first response referred OPC back to responses to items 01, 04, and 37. So I don't have access to 04 and 37. I'm not asking you to provide anything about that or tell me anything about it. But I just wanted to be clear that the People's Council did not interpret those responses as being responsive to this data response. Since these discussions continued, I have to assume that that's where you are.
That's right, Your Honor. And I mean, we think the request is simple. It's for audit reports, and we didn't get any of those in response to any of those questions. We don't have any audit reports.
All right, thank you, Mr. Cleaver. So, Mr. Curran, yes, Madam Court Reporter?
Oh, that's okay. I was just coughing. Sorry.
It's all right. Mr. Curran, if this request was narrowed as the People's Council had initially proposed, does it make it more palatable, something the company can still respond to?
It does. They had limited it in their agreement of the 6th to discussions of, make sure I get this lined up correctly. They narrowed it to documents that mention or implicate Potomac, Edison, or Maryland. We went back based on that agreement of October 6th and confirmed that the information in other states does not reference PE or Maryland. That was information that we provided them. They didn't like that, and that hence filed the motion here. But if it's restricted to PE, there are nothing in additional to what we have provided in our other DR responses, which they find lacking. But we augmented that, Your Honor, as I mentioned a couple hours ago, it seems, that we augmented it by providing them with all costs that have been allocated from FE to PE. So those are all the reports that, unless they are reports of other states, and we do not believe it was appropriate to go to Pennsylvania and Ohio and other states to see what those utilities had done. And that's what encompassed their, in our opinion, a very overly broad discovery request that goes outside the confines of your order to talk about funds of Potomac Edison. Again, that was what the commission limited the inquiry to. So, once it is limited to PE, we've provided that information. Again, Mr. Trout was very articulate about this when he says that we turned out our pocket on it. So if you, Your Honor, if you had in front of you DRs 1.1 and 1.4 and 1.7, you would see that that is information regarding journal entries that are related to the accounts at issue and refunds that we intend to provide to customers, as well as you're familiar now with 1.1, the spreadsheets that describe how the FES costs were allocated to PE. So yes, if we are living up to our agreement, then that's what we intend to do. That's what we have done.
Your Honor, if I could just add something very brief, just yes. A final comment. It sounds like from the responses we've received that there have been audits. An audit is not privileged, and we tied the request to the commission's language, this commission's language. We quoted from Order 89888 in the request. So any audit that addresses those issues very well could shed light on how First Energy is treating this effort to identify and refund money that utility distribution customers paid to fund these activities. It's a reasonably calculated response. Thank you.
Thank you, Mr. Cleaver. So, Mr. Curran, to be clear, again, the company has stated that they've turned out your pockets on this information. In saying that, I'm concluding that we're not suggesting that there are privileged documents that are not, they're in a different pocket, but that you have provided the materials that you have. You're on mute.
You're on mute.
Sorry, I was trying to get off of mute, Your Honor. We provided all the materials regarding Potomac Edison. That is correct.
All right. Then in that case, then I will once again grant People's Council's request, and it will be for any documents or materials that are in Potomac Edison's control. So my understanding is you've already provided everything you have, but to the extent there's other documents or materials that you may seek to use in the event there's a future proceeding, and I'm not stating that there will be, but if there is, those documents need to be provided to the People's Council. But it's my understanding that you don't have anything else, so.
Again, Your Honor, just to be clear, because OPC's original request was everything relating to every state. And
No, I'm sorry. This is limited to Potomac Edison, not to the other utility companies. Oh, excuse me, the other subsidiaries of First Energy.
so again, we supplemented this response on October 15th, and your instruction is if there's anything that got generated that's responsive with respect to Potomac Edison between October 15th and whenever discovery ends in this proceeding, we're to provide that.
You should provide that, but at the same time, any other materials that you may not have provided, again, related to Potomac Edison, that's in your possession. But again, it's my understanding that you've already provided everything, so that's almost a
Right.
word that doesn't really appear to do much, but caution that it does in the sense that if there's an additional proceeding, the documents you provided to the People's Council are the documents. Shouldn't be something else that suddenly shows up.
Okay, so what PE is provided with respect to PE, if it's not complete with respect to PE for some reason, we find we missed something, provide that. If there's something generated between October 15th and the end of discovery, again, from PE with respect to PE, provide that. That's the extent to which you're granting the motion.
Yes, and I guess, again, I'm not including this in my direction at this point, but I'll state the expectation that in the event there are privileged documents, the company will also communicate that to the People's Council, as I'm expecting company with all of the other matters that are here.
We'll have a discussion with People's Council about that.
Thank you.
Your Honor, can I just seek a bit more clarification on this? I think that Your Honor, at one point, I think it was Your Honor, but may have been counsel, but someone used the phrase, documents related to Potomac Edison. And I guess I would submit that there could be documents related to Potomac Edison that don't expressly mention Potomac Edison. And so, and that's that's why we want the information. Again, we're only looking for audits that are tied to the scandal, so to speak. And our aim and we represent, of course, as Maryland OPC, we represent only the Potomac Edison customers. But if we see an audit that was done with a specific methodology that talks about distribution utilities in Ohio, that's limited to this specific issue and using the language of this commission, and we want to pursue, well, why'd you do it this way for this? Did you do this for Potomac Edison too? Did you employ this process in your audit of this company that like you did for Potomac Edison? That's really what we're going for. So related to Potomac Edison, I think that if there's anything that's responsive to this, the question, it could be related to Potomac Edison, even if it's not called, Maryland Audit Report or a report that says a bunch of things about Potomac Edison at the beginning. So I'm not entirely sure where we stand in light of the order.
Sure. So I'm looking for the company to provide documents that are reasonably related to Potomac Edison and Maryland customers. Obviously, they have to have some probative value. And if they are, even if they're not admissible, ultimately found to be admissible here in an evidentiary proceeding, they at least should have we have to be able to determine that there's some ability to, that for those documents to lead to something that could be reasonable or probative. So I asked questions earlier about the possibility that some of the language in the shareholder, the ICANN agreement, was duplicated from other jurisdictions, and neither council had an answer to that. So I understand that sometimes the legislative language might look similar from one jurisdiction to another. Whether that means that a legislative language used in Ohio could lead to a similar review in Maryland. That's the example that you just gave. So that's far.
You're breaking up a little bit, Commissioner.
I'm sorry. I said I think that's a bit far, and I think it's more important that to the extent we find documents, or excuse me, that there are documents or materials that can lead to additional information, that is certainly information that the company that would be responsive. But we've heard Potomac Edison say multiple times that they've provided what they have, and so it's difficult at this point for me to say that there must be something else, and I don't know that I can. I don't think I can. I don't feel comfortable hanging my extension of that beyond just
Sorry, I hate to say it, but you're breaking up again.
breaking up. Oh boy.
Yeah, you weren't doing it at all until now, so.
I'm talking too much. So, and related to anything that is partially related to, or could potentially be related to what the company has conducted in another jurisdiction, I couldn't tie that just to similar legislative language. I think we need to have a little more than that. Something else that would demonstrate that there's something probable beyond that, that could reasonably result in some documents or evidence or materials that would be useful in evidentiary proceeding later. So I've been limiting it to documents that are within PE's control, and documents that relate to Maryland and Potomac Edison in general. But I think it would be too far to authorize the collection of documents that are or audits that might have been conducted for a different utility company in another state that could have been conducted as a result of other statutes or other regulations or other authority by the state government or any number of other reasons that are not duplicated here, even if there's similar language or something other than that. So I don't know if that answers your question. I hope it does.
It does help, Your Honor. I appreciate it.
Okay.
Yeah, thank you.
Thank you. So we'll move on to our final one for today. It's OPC 1-40 regarding legal consulting and personnel costs.
Yes, Your Honor. On this one, we've heard today a couple of times from counsel for PE that we've been given every allocation from SEC to PE over a certain time period, a number of years. But without having a full accounting of their personnel and legal costs related to the events in Ohio, we can't verify that none of them were included in the allocations. The references, as we pointed out in the discussion of 1.1 and 1.2, the allocations that are identified include references to a lot of organizations whose identities and specific roles we don't know. So without something to check those allocations against, it's difficult to really, perform the assessment that we're trying to get just from this long list that includes every allocation. So we tried to, this request was limited in such a way to get the accounting of costs related to the Ohio occurrences.
Mr. Curran.
Yes, Your Honor. In this request, they're asking for an accounting of all of First Energy's legal costs. They're not asking for Potomac Edison's legal costs. They're asking for First Energy's legal costs. We have advised them in a separate data request that 100% of those costs are being allocated to First Energy Corp. They are not being allocated to Potomac Edison. And as a result, it is not a charge, or will not be a charge to Potomac Edison. It's being allocated 100% to First Energy Corp. So again, we believe that this is outside the scope of this proceeding because the commission asked, limited it to funds of Potomac Edison being used for this activity. And now they're asking for all legal costs incurred by the parent corporation, in which we have confirmed for them that 100% of those costs are allocated to FE and not to PE. So we would respectfully request that you deny that request.
So,
Yes, I'm sorry, Your Honor, I apologize.
it's all right, Mr. Cleaver. I actually had a question for you. Why is the company wrong here if all of the costs are being allocated to First Energy?
Well, Your Honor, I appreciate that representation. In OPC's view, that's the right thing to do. That what Mr. Curran just described. But again, going back to kind of the earliest discussion of today in 1.1, OPC wants the ability just to go back and see what these costs are, so that when we get into the next rate case, where, as Your Honor knows, we're on these very tight timeframes in Maryland, it's 7-month rate case with a lot of different issues. This is something that we'll have lined up. We'll understand, and we can check and verify that, in fact, these costs were treated appropriately. Here's what the universe of costs are. Potomac Edison, Maryland ratepayers were not charged any of them, and we can move on. That's the result we hope to see, but we would like the ability to verify that.
Mr. Trout, you seem to be leaning forward.
I apologize, Your Honor. It's just sort of my posture, but I'm perplexed because we've put in a data request response specifically, and in the supplemental response to this, that there are no legal costs being allocated to Potomac Edison with respect to all this bad stuff that happened in Ohio, except what we have to pay Mr. Curran to defend in this proceeding. Okay, so and OPC's response is, well, let me see everything that every First Energy has paid to anyone with respect to all the bad stuff in Ohio. And then I don't know what they'll derive from looking at all of the outside counsel bills of all the other lawyers in Ohio, when the question is, did any of that get allocated to Potomac Edison? And they're starting with the answer, which is that it's none. So there's, saying that there is nothing is in itself an answer. It's providing the information that what you've asked for doesn't exist. We had that problem with some of the earlier answers. They don't like the answer that what they've asked for doesn't exist, but that doesn't change the fact that it doesn't exist, so we can't provide it.
All right, thank you, Mr. Trout. And well,
Can I, very briefly? And
yes, Mr.
I know it's been a long day. The answer to this question is not that these costs don't exist or that we gave you everything we have. The answer is an objection. So we're just trying to, we know there are outside legal costs associated with the issues that gave rise to this docket. And this is a request for an accounting of what they are. And that's it. And I'll stop there, Your Honor. I know it's been a long day. Thank you.
Supplemental response.
Thank you, Mr. Cleaver. So I'm in a bit of a hamstrung a little bit here because we're referring again to data responses that I do not have. So I don't know what information was provided there. I do know that those, based on what I'm hearing today, the People's Counsel is not satisfied with that information. So for the company, Mr. Curran or Mr. Trout, you stated here today that you've stated to People's Counsel that all of the costs, 100% of the costs, are allocated to the to First Energy. Has that response been provided in a data request, or has it been only an objection filed in the data request?
That's fine. So first of all, you have to look at not just the response, but the supplemental response, where as part of trying to resolve this, we said, we referred them to 3.3, and we also said there's no costs there are no costs, FE legal costs, that are being allocated to PE. The only meter that's running here is Mr. Curran's, and it's only for this investigation. They asked us a separate question, 1.5, and I know you don't have this one in front of you, but 1.5 asked, are the legal costs being allocated to PE? And in 1.5, I'll read you the last two sentences of the answer. All costs related to these investigations allocate to the same order number. That order number is settling 100% to cost center, and then it gives us cost center. And that cost center, in turn, settles 100% to company 100, which is First Energy Corp., which is not charged, allocated, or assigned to First Energy Corp's operating companies. So in the supplemental response to 1-40, we told them there's no money, no legal costs going to PE customers. In 3.3, we gave them the information that amounts to the same thing. And in 1.5, where they actually asked the question very directly, we said and showed by running through the account, explaining the accounting to them, that 0 of this is going to PE. So that's the information they asked for. That's the answer. They don't like the answer, so now they want to look at every legal bill of every First Energy entity with respect to this. And it's just ridiculous, frankly, Your Honor. It's wildly overbroad. And
Thank you.
Yeah.
Thank you, Mr. Trout.
Sorry.
All right. I know it's been a long day. Thank you. Any response, Mr. Cleaver, beyond responding to Mr. Trout's final sentence?
Thank you, Your Honor.
Sounds like once again they're stating that the answer, they provided an answer to your question, which would suggest that if there's no cost, there's no documents.
Well, I think that maybe it's a subtle distinction. We asked what are the costs? And then at first we got an objection, and then the supplemental response says, we're not going to bill any of the cost of PE. So and Mr. Trout keeps saying, OPC doesn't like the answer. I love the answer, Your Honor. I mean, I think it's a great answer. I'm really glad to hear it, that these costs won't be billed to PE Maryland. But our question was, what are the costs? And again, just based on an effort, again, harkening back to the discussion with 1.1, an effort to understand, how these costs were isolated, to get a sense of what they are, the scope of them, and it all for the purpose of confirming that Maryland customers aren't paying them. That was the question. The question was, what are the costs? We got objection, and then we got PE won't be charged them. Really glad to hear that, but just would like the ability to take a look and assess ourselves. That's all. Thank you, Your Honor.
Thank you, Mr. Cleaver. Just give me a moment. I'm rereading the data request 1-40. Okay, sorry for the delay. I apologize for that. I wanted to make sure that I was fully, and again, I'm somewhat limited because there's clearly some other responses that are impacted by this one. As a preliminary matter, I would limit this response to only the costs that were incurred by Potomac Edison, to the extent any were transferred to them. We're hearing again that there are no documents responsive to this, and because there were no costs responsive. But I don't want to limit the possibility that those, Mr. Curran's costs notwithstanding, which is of course money well spent, I don't think that that's cost that we're initially concerned about here. So I will grant in part and deny in part People's Counsel's request. It's limited to those expenses or costs that are directly accounted for or paid by Potomac Edison or billed by Potomac Edison by First Energy. I don't see that there's much else more here that we can seek, especially since there isn't, according to the company, there's no cost to attribute to Potomac Edison or Maryland. Again, we're in the same position as before. In the event that further proceeding is held and those costs are suddenly there, People's Counsel has a number of other remedies at its disposal regarding whether or not those materials are admitted into evidence. So we've gone through all 6 of the People's Council's data requests. I don't know if I said it at the beginning of the proceeding, but the board directions that have been provided here today, reduced rather to writing, so you'll get a copy of that. I don't know how long it will take, but you will see that very shortly.
Your Honor, can I ask one point of clarification? And I don't know what First Energy will do regarding your order on 1-2. But is that, just for a point of clarification, is your order limited to the identification of the vendor services that were misallocated as identified in that 1-2 investigation? You claim that there was a waiver. I want to see if there's any limitation to your order in terms of what's being identified in or being required to be produced in that report.
No, I'm I wasn't initially limiting it only because I wasn't sure exactly which where those vendors, where that information came from and what parts of which report we're talking about. Are you suggesting to me, and again, I'm not reopening my decision at this point, talking clarification. Are you suggesting that there are no other vendors?
No, all I'm saying is that you've asked for a report, and I don't know. I don't represent First Energy. You've made your order here, but wanted to see if that was limited to what had been articulated in the letter of June the 9th regarding the identification of vendor services that were either improperly classified, misallocated, or lacked proper supporting documents. I'm trying to get a clarification on what exactly you're seeking to have produced. That was the reference in the June 9th letter.
Well, let me turn to the People's Council. Would that satisfy your request?
No, Your Honor. The request is for the internal investigation report. That was, again, I know we've said these things and Your Honor already ruled. I appreciate counsel's persistence in trying to reopen the issue, Your Honor's ruling, but no, it's for the audit report that's been held out to this commission as a reason to deny OPC's petition and as a reason that an audit's not necessary.
It's not true.
The request is for the report, and we understood Your Honor's ruling to cover that, and our position would be that the waiver decision, that the waiver that has occurred is not limited to some very limited specific part of the report. It's the report. That's what we want. Thank you.
So I did not intend to limit it when I first made the order. And again, it's primarily because I was somewhat surprised at the fact that there potentially were 2 different investigations. And so I'm not entirely clear which report references the vendor analysis and to a large extent, I think that that's information that is very relevant in this case and does have probative value that needs to be reviewed.
Thank you, Your Honor. And I may have missed this, did you, Your Honor, did you indicate that you intend to have a written order memorializing your rulings today?
I do, Your Honor. Yes.
Thank you.
Are there any other matters pending or need to be addressed here today?
I don't believe so, Your Honor, and I would just like to extend my thanks. I know that no adjudicator likes to be forced to hear discovery disputes, and I know it's been a long day, so we really appreciate your time and your thoughtful consideration of the issues. Thank you.
Thank you, Mr. Cleaver. And I'll tell you that I was actually volunteered, so I don't know if that's a good thing or not.
You volunteered or were volunteered, Your Honor?
I did volunteer.
All right.
So this was think of me as you will as a result of that. But
You probably shouldn't have told us that.
So I appreciate all of your time here today. I know this lasted a little longer than we probably expected it to. But as I said earlier, this will be reduced to writing. I can't give a specific time as to when. I know we had two other parties here, both staff and Solar United neighbors. Did either of you have any other matters that needed to be addressed?
I do not, Your Honor, but thank you for asking.
Neither does Solar United Neighbors. Thank you, Your Honor.
Thank you. Thank you to both of you. Madam Court Reporter, we can go off the record.
Okay.
All right, thank you very much, everybody. As you might have known, this is my first of these types of proceedings, so a lot of fun. I appreciate it very much.
Thank you, Commissioner.
Thank you.
Thanks a lot.
Attention.
Thank you.
Thanks, everybody. Take care.
Take care.